We're live. Okay. What I love is that I am so neurotic. I don't like to be 5 seconds late to a live stream. Everybody, how is everybody doing on this Sunday evening, depending on where you are? First things first, let's see. The chat is good. Is my audio good? If my mic is not working, put a big F in the chat and I'll know. Hello, Uncivil and Viva, 420 Atheism. Okay, so audio's good. This thing's on. You will notice two differences, potentially maybe three differences. Oh yeah, hold on one second. Actually, before I even forget, I can't get Real Bambuga's previous super chat. I said he won the internet with it, but I took a picture of it so that I could read it. Probably the best, probably the funniest thing I've heard in a while. Real Bambuga said, "Hey Viva, can you help me advertise my new COVID mask?" I'm gonna try not to get in trouble with the comment. They're real coffee filters. Okay, that's funny. Funny is funny. Okay, so what was I saying? Two differences you're going to notice. In the background, I have taken down the ram head, which was causing some discussion among people. I didn't know what people were talking about, but no, there's nothing more to this. This is a HomeSense ram. I don't know who would spend $40 on this. I hope it was a wedding gift. But it was attracting the wrong type of attention, and people were reading things into it. Also, it was kind of spooky. This white ram head. So up there now is a picture I drew in high school of a frog. Anybody who has good eyes can see the full frog. That's one thing. Second thing, I'm using the camera on my computer. So I don't know if it's going to be better or worse than previous videos because I've got a new computer, the MacBook Pro Air or something. Anyhow, the camera looks good. Better than I think it looks better actually than the plug-in one that I've been using for a while, but we'll see. Why did I choose StreamYard John Schneider? Which one? One of the ones went down, and then this was a good alternative, and it's actually surprisingly easy to use, totally reliable, and free if you don't mind keeping the logo in it. The thing is, I'm so happy with this service. I want to keep the StreamYard logo in it because I think everybody should know about it. Worse, I think more noise for the camera. Okay, well, whatever. We'll live with it for now. I'll go back to the other one later for next week. Super chats. I'm going to thank everybody in advance for the super chats. I do my best to get to all of them. I'm going to miss some. It is to show support for the channel. It is not, as Uncivil Law once wisely said, it's not a right to entry because it sometimes interrupts the conversation. I'm going to bring them up even if I can't read them. But do forgive me if I miss them. But if you're going to get mad at me if I miss them, don't do it because it's going to put pressure on me that I don't like. Thought on Brett Weinstein's Unity 2020 plan. I have to look into it. I'm not sure what that is. Let me see. I saw three super chats. You need a t-shirt with a suit printed on it. Okay, I see Barnes in there. So now I'm going to get to these super chats. Oh, sorry, hold on. So I think I did all the disclaimers. Tony Nieves, Viva, can you and Barnes clear up at the start that Wisconsin law only restricts up to the age of 16 because all lefties, the law students, are claiming that it is illegal for him to carry at 17. So we actually talked about this last week. We're going to talk about Rittenhouse. We're going to talk about Strickland because now I've done my weekend of homework to get familiar enough with Strickland to ask Barnes coherent, intelligent questions. We're going to get into it. Bambuga says, if you can paint the ram head red, Satan will be your friend. No, it was always a weird thing in the back anyhow. It added nothing but distraction over my shoulder. Mother Issue says, please ask Barnes about the 14th Amendment, Section 3. Does it make Biden-Harris ineligible to hold office based upon their bail postings? Interesting. Robert is in there, so he's watching this now. I'm going to try to get to a few super chats more before we get into bringing Sir Bonds onto the screen. $2 towards the new light bulb. These things, you can't fix them either. I don't even know what the heck... I don't know what the deal is. They're LEDs and they go in and out, and like it's on a switch apparently, which you're not supposed to have a modulating switch for LEDs, but who the heck knows? I don't know what I'm doing in life. Video looks good on the new Mac. Don't do much for your mug though. Nothing can change this. Joshua, good to see you again. The hair is growing in, so that's the only thing that can do something for my mug. Okay, let's do this. Okay, sorry, I'll leave it up, but I'm not going to read all comments because I don't want to get myself in trouble through some of the comments. Bambuga t-shirt idea, defund the politics. That's not bad. How about just defund the government? Okay, on the topic tonight, before I bring Barnes in, we're doing Michael Strickland because Robert has been wanting to talk about it in greater detail and we never get around to it. It's going to be the good segue into the Rittenhouse updates. There haven't been really many factual updates, but there's more questions that we can answer. Elizabeth Warren. What else was there? Mail-in ballots and some other stuff. We're going to get to a ton of stuff. Oh, yes, that's right. Senator Lucas arrested and Mayor or former Mayor Fred Heidmann arrested. There's some updates in that because I actually listened to the council meeting, the emergency council meeting that they held Friday afternoon. Someone sent me the link and it was interesting to get like a window, a glimpse into, city council meetings. It's interesting. Can you and Barnes talk about the conflicting magazine ban ruling by the 9th Circuit and 3rd Circuit? We did this a couple of weeks ago. If we can get into it again, we'll do it. But we did it the week before last, I think. Okay. Robert has been patiently waiting. The angle on his camera looks good. Robert, how you doing?
Good.
Okay, it is pixelated, people, but that only has to do with the speed of the internet. Can't do anything about that. Robert, all is well on your side?
Yes. So the camera angle is a little bit better, as people pointed out that the genius didn't know how to move an HD camera, which is true. But I did figure out, yes, moving the camera was simplified. So it's no longer Hobbit Barnes. Hobbit Barnes was only last week.
We talked about this on Eric Hunley's live stream, but Robert is 6'2". I'm 5'6", and it was the first time in my life that I looked like the giant in any side by side.
Yeah, for anybody out there, Eric Hunley has his own. What's the title of it?
It is Unstructured Podcasts. He has a podcast, but his channel is actually under his name, Eric Hunley.
Yeah, it's great. He interviews lots of cool people. It's a lot of fun. And Viva and I were on this week.
Yeah, we did it. It was a good hour and a half live stream. We actually went past our allotted time with him, but that is par for the course with us in any event. We're going to have to do a Judge Sullivan update as well. There's been some updates there. Okay, Robert, I've done my homework now on Michael Strickland. I know you want to talk about it, and it's a good segue into the Rittenhouse, and it's a good framing of where we are now in general. If I'll summarize the facts as best as I think I understand them, and then you'll point out mistakes if I've made them.
Sure.
Michael Strickland is an independent journalist. 2016, he's covering a protest. It's not BLM. I forget the name of the group. He is, even by the Court of Appeals judgment, aggressively confronted by a number of protesters. Being aggressively confronted when he's trying to leave, and people recognize that he was trying to leave, he draws a firearm. There's video footage of it all over the place, left, right, and center. Doesn't seem that he ever had a finger on the trigger, had the gun pointed down, displayed it to frighten the people, which it did, but not entirely. Reholsters it or puts it back. And then people are saying, let him go, let him go. Even after that incident, 2 people are sort of shouldering him and not letting him go, but he gets out. Gets tackled by SWAT or police a short while later, arrested, felony charges for brandishing a firearm, among other things. He's found guilty of 10 charges of felony brandishing a firearm, even though only 2 witnesses showed up for the trial or testified during the trial. Confirmed on appeal, or was it not confirmed? There was something that went to appeal, which was admissibility of evidence as to his prior experience, having been assaulted and having his arm broken, which, it was going to be used in theory to provide evidence to his frame of mind for why he drew the weapon. Is that close enough to all the material facts?
Yeah, I mean, really, there was a few other facts, some that are pertinent for taking it up to the U.S. Supreme Court, some that would be pertinent to a habeas petition. But what happened at the trial level was, one, they lied about him. The prosecutor did leading up to the trial. There were a lot of false statements about him. They accused him of racism and a whole bunch of other things. Basically, if you want a script for how Rittenhouse is likely to be treated, and for all of these charges we've seen, including the St. Louis couple and other places, it all started in Portland, Oregon, in the prosecution of Michael Strickland. The weaponization of the prosecutorial offices to punish people who try to defend themselves began in the Michael Strickland case in Portland several years ago. And they just simply have been replicating it in all of these other cases across the country where someone has asserted any level of self-defense. They have been targeted. That's why what happened to the St. Louis couple was not a surprise if you were familiar with Michael Strickland's case. I think it's Laughing at Libs is both his YouTube page and his Twitter feed. You can find all the details about it. He's a grassroots journalist, a little guy, not physically big in stature. He had previously been assaulted by groups for filming them and exposing them. And this particular group had said they were going to target him. Antifa types and the same type of people that have been looting now over 100 nights consecutively in Portland. There was even video footage the police was aware of them getting together that day to assault him. The groups were anywhere between 5 and 10 people at different junctures. And they spotted him filming their public event. He's had, of course, a public right to do so, a right to free press to do so. And they kept approaching him throughout the day, basically telling him to get out. And then they were marching right towards him to assault him. And I think even the Court of Appeals opinion admits that one person, I think they call it pushing or something of that nature, but it's interesting the language they use when it's along those lines, when it's the politics is on the other side. And all he does, and between getting assaulted and that day, he had trained himself in self-defense in a proper manner. So he had a right to have the gun. He knew how to use it. He said, if you fear you're going to be assaulted again, you show it, you back away from them, show them the weapon, and then put it away. And he does exactly what his training taught him to do. And what expert witnesses would have testified to. He was denied certain evidence. A whole bunch of evidentiary issues happened at trial, which we'll get to. So the core is you have a little guy who's got a history of being assaulted by this kind of group. This group has a history of assaulting people like him in Portland. He simply, all he does is brandish a gun briefly while he's walking backwards, and puts it down, maybe just seconds. It's shown, and then walks away. And then but instead of none of them get arrested, typical Portland. Instead, he gets arrested. And he gets charged with a bunch of felony crimes of brandishing a weapon and so forth, of having a dangerous weapon and exhibiting it in a particular manner, etc. He hires a local lawyer. The local lawyer knows some good Second Amendment cases and self-defense cases, but is really not familiar with these kind of political cases. And so early on, they discover that the jury pool is very biased. And rather than move to transfer the case out of Portland and do a different jury trial, the trial lawyer recommends not doing a jury trial and having a bench trial. Well, there was no chance that that judge was going to give him a fair shake, but it was naivete on the part of his counsel. And even though the judge is handling the trial themselves, so the judge is going to see all the evidence anyway, whether it's formally admitted or not, they're using the case to try to set a precedent. And so they deny him a bunch of evidence throughout the proceedings that are essential to his defense.
Let me stop you with one question. Who's representing him? Is it a state appointed or is it his own counsel?
His own counsel. People raised money, kind of like what's happening currently with Rittenhouse. People raised money for his defense. But unlike Rittenhouse, they actually did hire someone that was familiar with Oregon criminal justice, familiar with self-defense law. So the lawyer for him was much more qualified than either John Pierce or Lynn Wood would be for Rittenhouse, but still made certain mistakes because they weren't familiar with how political cases work, didn't quite anticipate the politicized nature of the case in certain ways, so hadn't prepared in advance. And the big mistake was having a bench trial take place. But what's amazing is usually with a bench trial, the court just lets all the evidence in, so there's no argument about excluding evidence that matters. The fact that the court went out of its way to exclude evidence that was exculpatory meant they were trying to use the case to set a precedent so they could basically deny the self-defense defense to other people in the future in Oregon and could be cited in other contexts across the country. I was retained after the conviction to try to do an appeal and help with sentencing recommendations. He ended up getting time served effectively. I think he did 120 days in jail, if I recall correctly. They put limits initially on his ability to do his job. Some of that was restructured over time, and he got probation beyond that. And so we were able to help on that side. But the main goal was to establish a full self-defense he should have. There's the key piece of evidence that were excluded was one, the history of these groups of people, the violent history of these groups of people, including the violent criminal history of the individuals involved. Second, the what happened in terms of his past history of him being assaulted under these contexts and circumstances within the recent past, which is why he reacted the way he did. And third, statements he made to the police officers at the time of his arrest, which were exculpatory and went to his state of mind. Notably, as usual, as we'll get to later with the Court of Appeals in the Covington case, the Court of Appeals for Oregon pretends that two of those three issues are not before them and only addresses one of the three. Now, it's at least an implicit admission that our arguments were right on those issues, but instead they focus solely on whether or not you have to consider the subjective history of the participants in evaluating self-defense. Yeah. So and this has gone back and forth across the country, but to give people an idea, objective reasonableness was never meant to remove subjective circumstance or state of mind from self-defense. And that's a major miscue and mistake that lawyers have made and courts have made at different times over our history. Because what the goal is, like Wisconsin law is clear on this, but all law should be clear on this, in my view, consistent to both the Second Amendment right of self-defense, which goes beyond the right to bear arms, in my view. The U.S. Supreme Court in Heller said it's a right of self-defense. I see the right of self-defense thus as constitutionally anchored and rooted in terms of how statute should be interpreted. And then secondly, the Fifth Amendment right, that there has to be subjective intent, subjective mens rea, in the old Latin phrase, the legal terminology, before you can convict anyone of a felony. And when you do a pure objective test, you completely ignore the defendant. And what really ends up happening is judges end up substituting their personal political judgment for the reality of what took place. They start saying, well, if I had been there, I would have never done that. And that must mean it's unreasonable for him to have done it.
So actually, I'll stop you there just because there's three things we should get clear. The evidence that was not considered, the evidence that was dismissed, one was the violent past of the, let's call them the aggressors or the protesters, whoever they were, whatever you want to call them. So their violent history was not considered or was not admitted as evidence, which, some people are going to understand because the proof of character might be, they're not even the ones who are defendants. Okay, that's one element. The second element that was not, that was refused as evidence was his history of having been tackled by that other guy a while back, broke his arm in 3 places, was on disability, was traumatized, if not, had some sort of lingering psychological trauma from it, which made him, more susceptible to fear for his own safety, or at the very least, more precautious to protect himself. What was the third thing?
And the third was his statements to the police officer that were exculpatory that explained that. Okay. So basically what they did is they said nothing subjective matters. So like, for example, it would be like if Tim Pool was assaulted at an Antifa rally, Tim Pool couldn't talk about his own history, couldn't talk about Antifa, and let's say he tried to defend himself at some point, that he couldn't talk about any of that because it's not whether Tim Pool would have exercised self-defense, it's whether the judge would do. Yeah.
So here's the thing. Actually, Real Bambuga says 10 counts of brandishing a weapon. How many guns did he have? We're going to get to that as well. One gun, and it was one incident that lasted 3 to 5 seconds from what I saw. Mm-hmm. So here's the thing, and I was thinking about this over the weekend. The criteria is reasonable fear for your safety of an objective person, whoever that abstract objective person is. I understand the argument to consider the subjective element of that individual. But then the flip side is you get into this situation where an Amber Geiger type situation where you have what might be subjectively, reasonable in her own head, but is so objectively unreasonable. You get into the situation where if you admit of that defense in, let's just say Amber Geiger's case, and you apply it to Michael Strickland, you get into the situation where someone might have subjectively justified opinions to themselves, which are so objectively unreasonable based on their own, whatever the reason, that it shouldn't be a defense to what they did.
Yeah, and the key there is the language of the law is that what does the jury's being asked, what does the defendant reasonably believe? They're effectively substituting that so that if a defendant believes something and you have no doubt they really believed it, that isn't enough. The defendant's belief has to be reasonable, but it's still about the defendant's belief. They're basically scratching that. And they're saying, would a reasonable person have done what the defendant did? Not what did the defendant believe and why did the defendant believe it, and then whether the defendant's belief was reasonable. And so the net effect of that is it's going to ultimately over time impose the judge's own personal definition of what's okay to do and not do. There are a person's own personal, like when we were talking about Rittenhouse, we were like, well, we wouldn't go there, where we wouldn't have our loved one go there. This is creating a scenario where they can say, well, you know what? Rittenhouse never should have been there. So I'm going to say no self-defense. And I'm going to ignore entirely what was going through Rittenhouse's head, what was Rittenhouse's life experience, what was Rittenhouse's understanding. The other reason they're doing this is they want to exclude the evidence of the history of violence by Antifa. So not only, he had a personal history of people just like this attacking and assaulting him and threatening to assault him. They want to, so he had the extraordinarily strong evidence on this Accords that they excluded from the trial and for no particular purpose. Remember, the judge is handling the trial. So they're doing this solely to create a precedent. So in the future, you will be evaluated by whether or not the judge feels that the judge would have been there in the first place, whether the judge would have had a gun in the first place, whether the judge ever thinks it's okay to brandish a weapon in the first place. That's what's they're going to superimpose their own values.
Well, so that, this was my thinking, reading this over and listening to it on the weekend, is his personal history became not a red herring, but something of a distraction, because even by the Court of Appeal's own rationale, I could even set aside his personal history and say he might have been overly fearful, and set that aside. They're going by the objective standard when the Court of Appeal in their own language says he is being aggressively pursued or pursued aggressively by protesters. I think they themselves have eliminated the subjective matter. I don't see how they get around it. He's being pursued aggressively by protesters. He's entitled to carry a concealed weapon, permit in law. And yet it was criminally sanctionable of him to draw the weapon when being pursued aggressively by protesters. I don't see, even as a matter of fact, an assessment of the fact, setting aside his personal history, how they get to that point.
Oh, no, I agree. What they're really saying is that they're not going to allow people to exercise self-defense because they don't think you should. Because they think, what would a reasonable person do? They're going to substitute their own judgment. A reasonable person wouldn't have a gun. A reasonable person would never brandish a gun.
Well, or they're going to say if Strickland is so traumatized that he's so fearful that he should just avoid those situations and not put himself in a situation where he might overreact to what an objective, reasonable person would not overreact to. But even by their own description in the Court of Appeal decision, they acknowledge he was being aggressively pursued. So, and I guess taking it in abstractum, I don't know what incidents had occurred at the time this went to trial in 2016, but we see what happens when people get aggressively pursued now on multiple occasions. What's the status of the appeal now? Or what's the status of the file in terms of appealing the underlying decision itself?
Well, so we asked the Oregon Supreme Court to take it. They chose not to. So now our only option is the U.S. Supreme Court, which is always a long shot, of course. These days, they take 999 out of 1,000 petitions that get filed with the U.S. Supreme Court get turned down. And they may see this as a state law issue, but to me, it's a constitutional question, the scope of self-defense and whether the state law can be interpreted in this way. And because it has broader consequence for everybody. So in my view, they've got to, for example, in the criminal tax context, where I've done a lot of work, for a long time, they started reinterpreting objective. There's something called willfulness. You can't have committed a tax crime unless you were willful in what you did. And the court recognizes the complexity of tax law. It makes it easy to basically prosecute anybody, anywhere, anytime. And so they said, in order for you have to actually know that tax law prohibits your action for that. And unlike self-defense, its objective unreasonableness is only a factor to consider in terms of whether someone believed it, but it's supposed to be purely a subjective reasonableness test. And yet what courts were doing were effectively issuing directed verdicts and imposing an objective reasonableness requirement. And the whole reason objective reasonableness is there is for what you were talking about. Someone who has a crazy belief that what they're doing is in self-defense, you have no doubt they believe it, but you also have no doubt that they had no reason to believe it. It's not supposed, but what happens is judges easily, who don't like self-defense as a defense, gut it by saying, no, it's a purely objective test, and that's going to end up being their own personal judgment. And ultimately, it's going to gut the ability of self-defense, especially here, where we all know what the circumstances are now. I mean, if you studied it back then, you would have known it then too, if you'd been a Tim Pool type. But we all knew that that kid had every reason to realize, Michael Strickland, if he doesn't pull his gun, he may get beaten, he may get killed. But from the sort of naive, the evidence that proves that, all excluded. He's not allowed to present any of that. He's not to say, look, people just like this have assaulted me before. Okay, they've made threats.
And stop there. I mean, now in Canadian civil law, if evidence is not permitted, there's an immediate, you have a right of appeal right away, without going to the trial, without going to a judgment, which will have an impact that can't be undone. Did he appeal that refusal of evidence at the time, or did he wait until the judgment had already been rendered?
In America, you have to wait until judgment's rendered.
Okay, I think, and I want to make sure that I'm 99% certain. Dismissing the admissibility of evidence is appealable of right in Quebec civil law. This is now when you say a bench judge, a bench trial means it's a judge. There's no jury that has to appreciate the evidence or the admissibility. The judge does both.
Correct.
And the judge does not consider the evidence, renders the judgment. It goes to the Court of Appeal. Court of Appeal, from what I read, I think I read it was a 6 or 7 page judgment, says his past experience, that's a neoplasm, his experience it was irrelevant to the test. Nonetheless, and I think they can still get around it. Okay, fine. It was not relevant, but nonetheless, he was being aggressively pursued, and it was not a reasonable response for protection. How do you appeal that to the Supreme Court when it's going to be based on the assessment of the trial judge and the consideration of the appeals judges?
It violates the Second and Fifth Amendment rights because it basically negates mens rea under the Fifth Amendment, because it basically says that his state of mind is irrelevant to a defense that's all about a state of mind. Because and that's, while they don't say that about the issues they didn't rule on, that's the ramification by what they did rule on. Because what they said is it's purely an objective test, which most courts have rejected that. Most courts have recognized it's not a purely objective test. First Oregon court to say it in that way, period. And so it's deeply problematic. By the way, by contrast, they actually cite the case. They use that objective test measurement as a way to protect people who weren't really defending themselves, who had notice and knowledge of other facts, to protect actual criminals from prosecution when they were shooting at police and other people. So it's so political in Oregon, the court system there, and it's very dangerous what they're doing, because if what they're doing is upheld, self-defense does not have the meaning that it has always had in American law, and in my view is protected under the Second Amendment. So the argument to the U.S. Supreme Court is twofold. Question presented number one: does the Second Amendment require subjective circumstances of a defendant to be considered when evaluating the reasonableness of their conduct under a self-defense privilege assertion? And secondly, does the removal of a subjective intent violate their due process rights under the Fifth Amendment, under the Winship Doctrine that the Supreme Court has established, which basically means that if it's a felony crime, you need to have subjective mens rea as part of it.
Okay, and now can we explain how he got convicted on 10 felony counts when only 2 witnesses appeared based on 1 incident of brandishing a firearm?
There are all kinds of issues, but technically there was video footage also admitted, and there was testimony that came in that a certain number of people witnessed it. And so the fact that so many of their witnesses did not even show was a factor that the trial court ignored in favor of the fact that there was testimony that more than 2 people witnessed it.
Okay, and I had one other question. I think, well, what is the status now? Have you filed?
No, the Oregon Supreme Court only turned it down last week, so okay. We're on a 90-day clock to file the petition to the U.S. Supreme Court. So that'll happen this fall. I fought, even when it's an uphill battle to file in the U.S. Supreme Court, I always do, because you never know when your argument will, anytime you get a chance to get 9 Supreme Court justices to hear an important issue, even if they don't take the issue, you've planted the seed of the idea. And I've been doing this now for 15 plus years, taking cases up for that purpose. And I've seen it in cases they haven't taken of mine. I've seen the idea and the argument that we initiated and instigated show up in Supreme Court rulings. So it's always a good idea, but it's critical. I mean, if Strickland can be denied this defense, everybody can be denied this defense.
And Dapper Dave 527 says, can the DOJ join in the case by Strickland? What's my problem here? Can the DOJ join in on a case by like Strickland's when it is believed the Constitution is being abused by the state to fast track to Supreme Court?
They can. I don't anticipate that they will. So the Attorney General Barr has been very sporadic at what he's done on this accord. Now and then he steps in, but it's very rare for them to step in and second guess a state prosecution.
Okay, now one other thing. Tell me if I'm wrong. Well, actually, I had a question about this. Apparently, he was prevented under the judgment. Was he prevented from speaking on the issue and from reporting on subsequent issues? Effectively gagged? I mean, I didn't understand that, but that was what I understood.
Yeah, that was and the original scope of it was much broader. We did get it shrunk down. But yes, originally they were using it basically to prevent him from practicing journalism, preventing him from being part of the free press, preventing him from commenting on these individuals that were complicit in it, that of course would reappear in many respects. And so that was brought back, but it gives you an idea of what the mindset and what the mentality was. The prosecutor, the fact they even brought prosecution, the police even made an arrest, the kind of charges they brought, the way in which they lied about him for early on, the way in which they couldn't even get a fair jury pool and ended up with a bench trial, and the fact that the appellate courts and Supreme Court is turning a blind eye in Oregon to the gutting of self-defense and politicized cases it shows you where we're at, and it shows where the rest of the country's going to go if certain political actors prevail.
Okay, now I had one question, or a few which I took pictures of, because before we get into the next subject, Michelle M. First of all, thank you very much. I brought it up, but I didn't read it at the time. Is there anything your supporters, talking about us, can do in a tactful way to help Barnes receive full consideration to rep the Rittenhouse case? Pierce is a civil attorney, if I am not mistaken. Also, never heard of Strickland until Barnes. So first of all, I never heard of Strickland until you brought it up a month ago. It is eerily, what's the word? What's the word for premonition? It was prescient of McCloskey's and what we're seeing today. Yes. Also prescient in that we see what we've seen now, what happens when there is no defense exercise. We see what happens when there is maximum defense exercise, and which all seems to result from this sort of politicizing of the prosecutorial process. What can we do to help Robert? Other than the last live stream, 110,000 views. If the families are seeing this, they know that they know who he is and what he wants to do. You can't reach out directly to families. At least the attorneys can't, but I don't think anybody else should.
They're not supposed to, but apparently if you're Lynn Wood and John Pierce, you ignore that.
And then I think that, let me see if there were other super chats on this particular question. Okay, we had TB/AI says, thoughts on Palm Beach Mayor, Vice Mayor, Commish, and County Administrator having all been served non-negotiable notice of complaint in violation of operating outside their oaths authority of office by shutting down the county. That's not on subject, but maybe we'll be able to get to it. Oh, David Reed, is there a way to hold BLM Act Blue financially responsible for the destruction?
Not likely. It's just very hard because that's why they're organized the way they are. That's why Antifa organized the way they did. So, you might be able to sue the foundation and organizations that are receiving money, but proving causation connection, very, very hard. That's why they're organized like terror cells, and it makes it very, very tough to sue. To have someone specific that you can sue with an attachable asset for which you can blame for a particular set of actions. They're deliberately designed. They're not designed. Also, like Southern Poverty Law Centers misled people for years about "quote unquote" bankrupting the Klan. They sued an empty shell entity that nobody was a part of and "quote unquote" bankrupted them in most of these cases. They give you an idea. The foundation, the guy who founded Southern Poverty Law Center used to represent the Klan. Then he realized there was more money on the other side, so he flipped. So it's not. I haven't taken them seriously in a long time. They're very political, of course, these days, and misuse their position and power. I mean, they're the Southern Poverty Law Center, and they appear to pay almost no attention to either the South or poverty. So, yeah.
Well, and we've seen it. Like we've seen. I mean, I've followed it relatively closely. I mean, I think the last case that I think was a decent civil rights case was the Willie Nash case. That was that SPLC or was that the ACLU? Oh, I forgot.
And there have been some cases where they have been involved in and have been good over the years, but it's not the dominant focus of what they do.
I mean, I follow them on Twitter. It seems overtly partisan political, but that might be my own bias reading into their tweets, but I don't think it is.
No.
Karen Strand says, did you get my comment last week? Strickland's link on Wikipedia, Michael Strickland, amalgamation page, led to Don't Shoot Portland's Wikipedia page. I didn't get that comment, but that's interesting in any event. Which is a good segue. We're not missing anything with Strickland. I mean, I think we've covered it, and it's for anybody who hasn't known about this, as I didn't up until 2 weeks, or let's say 3 weeks ago. I was going back and watching the videos that were posted in sort of chronological order, and it was amazing. Project Veritas had a video on it. Then I saw a video of Strickland following up, talking about how his parole officer brought him back to court because he mentioned the name of one of the attackers and a possible suspect for another crime. Very interesting. And interesting seeing where it went, and interesting seeing where we have gone politically and prosecutorially since that case, which I was not awake back then. Do we go to Rittenhouse now?
Sure.
Okay, so Rittenhouse, everybody knows what's going on with that. There haven't been any new factual developments, but I know people have questions on a couple of things. So right now is he still in jail, or did he get out on bail?
Nobody showed up at his extradition hearing other than a public defender, so he's stuck in jail until the end of September in Illinois. Okay,
and now, so apparently the judge, I don't know what the proper term is, but the judge issued a $2 million bail.
Yeah, that's out of Wisconsin. So he was issued no bond out of Illinois. For people to give you an idea of the background, Illinois has bond, so you can get bond, and that means in most state proceedings you can get bond, but with a percentage of the cash amount. So if they say like $10 million bail, that means $1 million cash. You get a bail bondsman to put it up. Usually give the bail bondsman some less security even than that often. And sometimes you have to come up with that amount. Sometimes you can substitute other forms of security or collateral for it. So you can usually get out pretty quickly in a lot of cases, unless the bail's really, really high, when you have a bond system available to you. By contrast, Wisconsin has abolished that. Wisconsin's bail is one of twofold. It's either cash bail or a signature bail, where you're put out, say, a signature bail where they say, okay, you're going to forfeit X amount of money if you don't comply with the conditions of your release. In Wisconsin, in a murder case, they typically impose cash bail of a substantial amount. In Kenosha, that woman who also exercised self-defense, in my view, against her sex trafficker, who they're also prosecuting for murder, same Kenosha prosecutor. Reason why he's doing all this, by the way, he has no challengers. He had no challengers in the primary. He has no challenger in the November election. So he doesn't have to worry about political pressure, which is something I think needs to be remedied. He needs to face some political consequence for his politicization and weaponization of his office against the self-defense privilege in Wisconsin, in my view. But what the Wisconsin Circuit Court Access Program, you can access anyone's civil or criminal case right online. We used to call it CCAP in Wisconsin, but CCAP can mean other things these days. So just look up Wisconsin Circuit Court Access Program. You put in somebody's last name, it'll bring up all their cases. And Rittenhouse has a couple of minor traffic things from, I think, a couple of weeks before the incident that are up there. But the main case is, of course, all the homicide and reckless endangerment charges, plus the misdemeanor gun charge. And they've put a appears to be $2 million cash bail on him, which is not a surprise. They put $1 million cash bail on the lady who defended herself, and here you have 3 homicides. So they
put $1 million bail on the woman who brandished a firearm.
Yes, and she had to fight
in jail unless she posts either. Is it $1 million, not the 10%?
Yeah, that's the key. 10% comes from bond states. So it's bond states where you get to post 10%. Wisconsin, you have to post it all. If it's cash bail, now they can always reduce it to a signatory bail where somebody with collateral can do it. But but that's why it's critical. The Strickland case is a warning sign for everything we're experiencing now, McCloskey's, everybody else. But it's also a warning sign of what can happen to Rittenhouse, because Strickland just brandished his gun. He didn't use it on anyone for just seconds, walking backwards, and he got convicted and got railroaded. And this will happen to Rittenhouse unless he has the best defense, and large parts of his defense are already missing that should be present.
I'm still flabbergasted by something. The woman who brandished the firearm in Wisconsin had to post $1 million bail, failing which she would be stuck in jail until her trial on having brandished a firearm.
Well, in her case, she used it. She killed the guy.
Oh, wait, then I might not be thinking of the right case. Which one am I?
Right,
Which
yeah.
one?
You may be thinking of a different case. This is the woman who was sex trafficked, was constantly assaulted by the individual. He was actually under investigation by Kenosha for his sex trafficking and abuse and rape. And she finally defended herself one day against him and killed him.
Okay, I was totally thinking of a different example because that will change a lot. Sorry. Okay, so Wisconsin is cash bail. Illinois is bond.
Yeah, you can get bond in Illinois. So that's where, like, if you structure the defense well, the things that needed to happen was they needed to make an early aggressive pitch. There's extradition defenses he has available to him. Bring in politically connected Illinois counsel. Bring in a good extradition lawyer. That doesn't have to be Illinois. It's good if it's Illinois, but extradition is its own animal, and both intrastate extradition and intra-country extradition share similar principles and precepts behind them. And there are ways in which you can use. I've used extradition effectively in many cases. I did it for Larry Williams, the daughter of Michelle Williams, who was the partner of Heath Ledger for a period of time. A great investment guy. Used his extradition proceeding in Australia to leverage the government to agree to a wide range of deals. Wesley Snipes got a very favorable bond because he happened to be in a country that did not have extradition to the United States at the time of his indictment. I'm not saying that's a coincidence. Maybe it was, maybe it wasn't. But it was what it was. Either way, the government negotiated a fair deal when they planned on locking him up pending trial. To give you an example, that other Wisconsin case, she was in jail for over a year, I believe. And what's the risk to Rittenhouse is that he is stuck in jail for a criminal murder trial in Wisconsin can take 2 years to get to trial. He's stuck in a bad jail for 2 years, while Antifa types are already threatening in public settings that they're going to try to kill him or hurt him while he's inside. And I guarantee you the government's going to try to plant informants next to him to create stories. Because here's the key risk for Rittenhouse. His one risk, I believe the videotape exonerates him across the board. That's my view. But the best evidence from a jury perspective or a judge perspective or a prosecutorial perspective, and you're going to be trying to persuade all three at different junctures, is the video evidence for the second and for everything that happens that when he's on the ground. And that's the second charge. That's the third charge. That's the fourth charge. But the first charge, the first intentional homicide charge, we don't really have great video footage of. The forensic review to date, and that's why there needs to be those kind of people involved early to make sure evidence stays secure and that reports don't get lost. People should watch the Perry Mason show that was on HBO this past season for the founding of Perry Mason to understand the significance of that, of how bodies get moved, if evidence gets lost, and evidence isn't timely preserved, if it isn't analyzed within a certain time frame, certain things can happen. That evidence of the people are claiming that the forensic evidence of the first person that was shot, that the angle of the bullet, where the bullet coming in from the back, the bullet coming down, they're going to use as evidence to claim that couldn't be self-defense. There's a lot of reasons that one could explain that consistent with self-defense, but that's one of his weakest links in any conviction on any of the counts, and he's looking at potentially life in prison in Wisconsin. Then the other part is they're going to pursue what we talked about last week. They're going to pursue a provocation theory. Now, luckily in Wisconsin, I know we got some inquiries through social media that some conceal and carry experts are saying, oh, he shouldn't have even been there in the first place, so he doesn't really have a self-defense. They're thinking about provocation because in some other states, provocation is really a broad exception to self-defense. It's not in Wisconsin. In Wisconsin, in order for them to be able to show that provocation really matters, they've got to show that he went up there with the intention of provoking people to assault him in such a way that he could use deadly force against them. But it's already happening. If anybody knows Antifa and has studied Antifa, the Michael Strickland case, a little bit of preview, given false statements they made outside of the court proceedings relating to that. Now, he had a partially good state trial lawyer. His mistakes were not understanding a politicized case, but he did do state criminal procedure. So some of that falsified evidence never showed up in court. But their MO is they're going to have a bunch of people step forward and make claims that aren't true. And they're going to say, oh, he told me, Rittenhouse told me this. I heard Rittenhouse say that. And they're going to, like, for example, you want to lock down right away people who went to school with him. You want to lock down anybody who was there. You want to lock down a wide range of witnesses. I see no evidence that's occurring. I do see evidence that Antifa types and people who oppose Rittenhouse are doing it. So not only did nobody show up for his extradition hearing the first time, so that the public defender has to postpone it for a month. So he sits in jail for a month with no bail of any kind, which is problematic on its own terms, and lost a window of opportunity. But the other side is getting to his classmates. The other side is getting to other people that can create this false provocation narrative. So that's his other sort of factual risk. And of course, all problematic risk if he can't get money for bail. It's problematic if his bail isn't reasonably reduced. It's problematic. You could use the extradition proceedings to get a more reasonable bail terms out of Illinois, show that he will comply with that. Let's say you fight the extradition for 6 months, and let's say you get the equivalent of, say, $200,000 bail. You could still be the same $2 million, but say they put $200,000 on it. That a bail bond's been posted. And then you can use the argument that even if he loses the extradition fight to Wisconsin, that there should be a lower bail amount because he's already complied consistent with the Illinois amount. I mean, I call it reverse engineering. You look at, what do I need either a judge or jury or a prosecutor to say or do by the end of this case? How do I get there? And I reverse engineer the roadmap starting with the end, not the beginning. The problem is, and to give people examples, this came up in a different context. Cassandra Fairbanks was talking about how she was shocked at judges giving custody to abusers. And I said that I mentioned briefly on Twitter that was one of my first experiences with corruption in our legal system was a judge who did that in a case that I was not personally a part of. But it was a colleague of mine was handling the case. And I was so shocked. I mean, here's the backstory. The kid described in horrible personal detail as a 7-year-old boy the kind of abuse he was subject to by his father. And I was shocked when they came back and said that he got part custody. I was like, how did that happen? And the lawyer, much older lawyer, very experienced, very politically well-connected, started this public interest law firm. The two of us were the two lawyers for the most period of time. And he said, he goes, the judge fell asleep because the judge has a untreated diabetes issue that he often falls asleep during proceedings. And I was like, what? And then I was like, well, I'm going to raise a stink about that. And he's like, well, think twice about that. He goes, every judge in town is going to hate you. Every judge in town is going to hate our public interest firm. Every judge in town is going to hate our other clients. So I was like, man, this is screwed up. That was from that day forward that I said, I'm going to live in a place I don't practice every day. I'm going to be able to, I'm going to have a mercenary style where I can come in and say anything about anybody, any place, anywhere without worrying about 3 years from now, them not coming to my July 4th party or my Labor Day party. Because that was deeply, deeply problematic. I did address that judge down the road, by the way. That's another story. I didn't forget, and I haven't forgiven either. Some things are not forgivable. So that's just my treatment on it.
Okay, so Robert, I mean, it's now things are making a little more sense. The extradition issue at the beginning would have been extradite him to Illinois,
from Illinois to Wisconsin.
No. Well, but he's in Wisconsin now.
No, he's in Illinois.
So which state is it that then has the bail, the cash bail or the bond?
Where the alleged crime was committed is Wisconsin. That's where the $2 million cash bail is. They issued an arrest warrant. They stick a $2 million cash bail on it. They do that because sometimes somebody's arrested in some other county and they want to make sure that judge or magistrate knows, okay, this guy's supposed to have a $2 million bail on him before I release him. Let's say he gets arrested in La Crosse before they release him to appear in a case in Kenosha. But he tried to turn himself in that night. They didn't. The cops were too busy dealing with everything else. So they just just get out of here. And so he went home to Illinois, and they issued and so they not only charged him, they rushed the charge, which should have been criticized right away, but they had Illinois claim that he fled. And so they did an extradition warrant on him on Illinois so they could grab him and throw him in jail. So he's being held and on no bail as of now on an extradition warrant in Illinois about whether or not to extradite him to Wisconsin. They're setting this up so that he'll be stuck in jail maybe all the way through trial, which could be 2 years, which is a major problem, both for his safety and for his defense.
And I'm going to ask the obvious question here because I think I know the answer. If the family ever reached out to you to represent them, you would be 100% game.
Oh, yeah. I'm not my criticism, which I'll get into more detail in a minute about the current defense team tactics, is not because I'm not one of these second morning quarterbacks that I'm not going to be willing to put my own neck on the line and my own reputation at stake that's not the case. So I'm not doing it because I want the case. I'm not doing it because I would never take the case. I'll get into why I'm raising these issues now. But I'll give people the background. This is not a fire I started. There was a fire other people, the Billy Joel song, the fire, we didn't start the fire. It's been burning since the world has been turning. What happened was a bunch of people reached out to me, other state criminal defense lawyers, other members of the press, other community people who are getting increasingly concerned about what was happening in Rittenhouse's defense, both in terms of what would happen with the money that was being raised, how the money was being raised, to whom it was going to go, whether they were hijacking his defense by monopolizing the money. And the first immediate concerns was there's a bunch of lawyers who are interested in helping out here. And so it's not just, my involvement. I'm happy to help out however I can help. And we'll do whatever I can and do it at, no cost if that ends up being the necessity. Because this is a 17-year-old kid that I think is getting railroaded by a politicized prosecutor. And he came up with, my kind of background. He's a poor kid with a mom who's got a young sister. And I don't like what they're trying to do to him. So so for just that reason alone, I would help out any way I could. There's a bunch of other lawyers who are wanting to help out, who have great background in state criminal defense. Others who have background in extradition law. Others who have jury trial experience in both Wisconsin and Illinois. Others who have experience in politicized cases. People are willing to volunteer their time. There's security companies willing to help. Private investigation companies willing to help. I think this is a good area for crowd. Essentially, because there's so many videos out there, this is a good area for crowdfunding. This is not crowdfunding, but it's crowdfunding too.
Knowledge crowdfunding or crowdsourcing knowledge.
Yes, exactly. That's it. Crowdsourcing. That's the word. I keep missing that darn word.
And I was talking about this with my wife the other day with the guy who shot the Trump supporter, identified by 4chan within 24 hours based on stitching together video, audio, previous interviews, previous footage. It's the knowledge of the aggregate of the internet is better than the CIA and the FBI. I mean, I think they know it. With what can be done with this, it's there. People should. I imagine people are already doing it, but yeah, it's the way to go.
And it's going to be more critical because you're going to have these liars come out of the woodwork and make up stories about Rittenhouse. So you look at all the great crowdsourcing, people like Tracy Beans, people like Brian Cates, people, I think one guy's called Undercover Huber, another, they have different Twitter handles. But if you just ask Lee Smith, who's done great work, investigative journalistic work on everything related to Flynn, and I think he has a new book out called The Permanent Coup. He credits them. The crowdsourcing of investigative research has been fantastic and off the charts. And this is an area where this kind of case is where that would be very helpful. So, putting all of that in motion. So nobody's showing up at the extradition. So there were a bunch of technical things that were happening where the ship was already sailing, where he was getting behind, the way Michael Strickland's lawyer got behind in certain aspects, but much worse than what was happening in Strickland's case. And same with the court of public opinion. And then there were just fundamental concerns that the lawyer you would want in these cases, one, you'd want a dream team, an OJ style dream team. You'd want lawyers that know Wisconsin juries. You'd want lawyers that are politically connected in both Wisconsin and Illinois. You'd want lawyers that know self-defense. You'd want lawyers that know Second Amendment. You want lawyers that know extradition. You want lawyers that know bail. You want lawyers that know state criminal defense in general, because there's a certain state criminal defense in almost everywhere in the country has more in common than state criminal defense does with, say, federal criminal defense. So you want that kind of experience. You want that kind of background. People have been through the wars, people who know what they're doing. And then in the court of public opinion, you want people who are good on the criminal defense kind of cases for the court of public opinion, and know that you want to align it. You want your ultimate defense that you're going to present to a judge, a jury, and prosecutor. Prosecutor you're trying to persuade to drop charges. A judge you're trying to persuade either to dismiss, or you may, worst case scenario, deal with the appeal or sentencing. And a jury, of course, for acquittal. You want that to align with whatever your court of public opinion defense is. You don't want there to be a contradiction. And for part of the court of public opinion, you're trying to raise money to because he needs three things money-wise: legal counsel, bail, and safety and security. He's not going to be able to get a job let's assume he gets bail. He's not going to be able to get a job while this is going on that's safe. He's going to be subject to target or of harassment on a massive scale. And same with his family. So they need money for themselves to be someplace safe and secure, and money for security while this case is going on. I've dealt with this in multiple contexts. I mean, I got Amy Cooper out of a difficult, what would have been a difficult situation that she stayed where she was at. So you have to know that in advance. Otherwise, you're stuck in some disastrous situation. And plan. You need to plan in advance. You need people who are familiar with that, and people that are participating in it. So people started emailing me and talking to me, and people had asked me off the record on a wide range of cases, but this case as well, that were following this case. What do you think of Lynn Wood and John Pierce? John Pierce is in L.A. Lynn Wood I've dealt with in the Covington matters, so they knew I knew something about them, and I looked at their backgrounds for other reasons for other cases that I'd looked at possibly working together with Lynn Wood on a case, and I told them I wouldn't hire Lynn Wood for any case anywhere. I wouldn't hire Lynn Wood for a garbage ticket case. I have zero confidence in him. There were a range of reasons why, and they got agitated at me. They're like, okay, you're saying that privately, but you're saying nothing publicly while this kid may get hung. And I was like, okay, I have to reconsider whether I'm going to talk publicly or not. And then secondly, with John Pierce has a Michael Avenatti type reputation out of LA. So what you want in a lawyer running a Rittenhouse defense are people that are familiar with state criminal defense and trials in Wisconsin and Illinois and know the politics in those areas and have familiarity with issues of bail, extradition, state criminal defense, self-defense, Second Amendment, etc. What you don't want is somebody running the money that's being accused of fraud or misappropriation of funds that may owe substantial debts to their business partners or lenders related to litigation. And what you don't want is people being accused of being basically having mental issues right now that suggest a lack of mental stability, frankly. And then third, what you don't want is people who are making a bad, like the worst possible court of public opinion defense for Rittenhouse is to say he's an armed insurrectionary who's part of the militia. Well, that's exactly what John Pierce has said about him in his first two.
Yeah, incidentally, someone had posted that comment a while back. I brought it up, but was it a good idea to go on Fox News and confirm or admit judicially that he shot the three people? Because it's not clear. Forensics may disprove that possibly.
Particularly as to the first one.
Well, and then now someone else had asked this question. Seems that with the two that he shot, while running, the two that they have video evidence for is going to be presumably an easier defense to the extent one can have an easy defense. But the third one, so how do you go about tackling the third one that we don't have good video evidence of yet?
Well, that's where you need to round up all available evidence. I guarantee you there's other video evidence out there. You need investigators hitting the ground to find it. You need people who are going to infiltrate Antifa, who are trying to hurt this kid. That they will end up disclosing evidence that cuts both ways. If you know how to, I did that in multiple cases. You need high quality. You need to treat it like you're the government and you're prosecuting his defense, as if like a prosecutor would. And that means you use undercover research and undercover investigators, forensic experts. You bring in autopsy people. You bring in everything, every possible conceivable means you could have to defend someone. You do. So I can see why his defense could be expensive, but it wouldn't have to consume all the money. And if you're going to make a trade-off, take a cut in the legal fee to make sure he gets bail. So I started getting bombarded. I'll give people just a general background. That's the reason I was telling the judge story. Why do lawyers, because I get this question a lot, why do lawyers not talk about judicial misconduct that they witness? Why do they not talk about legal issues? So I had a lot of criticism of the way Roger Stone case was handled. I kept most of it private. I had major criticism of what General Flynn's corporate counsel, not Sidney Powell, corporate counsel was doing. Sidney Powell's been great. I kept most of it private. And the reason why most people do is that as a lawyer, there's no winning by criticizing another lawyer in a case, particularly if they're a high-profile lawyer, particularly if they threaten people all the time with litigation and complaints. All you do is make yourself a big, fat target. That's it. Your reputation will take a hit inevitably. People will dislike you and believe false stories about you inevitably. And that's why lawyers generally don't do it. I don't do it for different reasons. I recognize that lawyers can make mistakes. Lawyers can go through different things that may be difficult to read the situation from outside, and the rest of it. But I've come to regret that more. The Stone case, more commentary probably should have been made. It could have probably maybe made a difference. Didn't matter ultimately with the commutation, but could have had a fair trial maybe. Same with General Flynn. He may not be in the situation he was in. Because I had a certain platform, my commentary might have reached more people sooner, so he could have taken corrective action quicker. And so when this was happening, basically what I'm weighing is, okay, if I talk, it's going to hurt me. There's going to be no plus to me talking about these issues with Pierce and Wood. But the person who's going to suffer here is if I don't talk. If I do talk, only I suffer. If I don't talk, I'm fine. But if I don't talk, the person who suffers is a 17-year-old kid who may get railroaded for life, who's just a poor kid trying to protect a neighbor, in my view. And honestly, that's an easy trade-off. So that's when I decided, enough was enough. And I started getting all kinds of comments bombarded, frankly, from state criminal defense lawyers with people saying, this is a disaster. This is a disaster waiting to happen. These people do not have the background. They're making fundamental mistakes. I got that. And then I found out a top Wisconsin defense lawyer had been approached to do the case and wasn't interested in doing the case as part of the team because he had zero confidence and trust in Wood and Pierce, and he didn't even know their background. It was just interacting with them. He was like, I'm not getting near this with these people. This is a circus.
And it's a funny thing because we had talked about this previously, like how do you take a battle to social media? What are the do's and do not do's for a lawyer going to social media? I think you do it relatively well. And I'm that's my assessment. Looking at what's going on social media with the other lawyers and what they're doing in terms of public statements, this may be one of the cases where they're not doing it well, or they're doing it in a way that's not going to help the case in the long run. And you begin to question it. I don't know. That was more.
Yeah, and for people in that respect, I mean, I did. Some people think I just jumped on it right away. I started publicly criticizing. I did not. First of all, I was reluctant to do it for the longest time. Then realized, okay, the kid's really in harm's way. I may be able to say something that corrects that. So I'm going to go ahead and start saying something. But I started out by privately messaging John Pierce and said, look, I'm happy to help. I know a bunch of other people happy to help. I know some of the top Wisconsin criminal defense lawyers happy to help. Top Illinois criminal defense lawyers happy to help. Extradition experts already willing to help. Bail experts willing to help. But I just laid out for him. I said, I'm just generally, I said, I'm here to help out. I said, here's what's important. The financial concerns, please just come out and say that with all the monies raised, you're going to give it to the mother. And she will be picking counsel, and she will have money available for bail, and they will have money for their private security, and they get to make those choices. He refused to respond to my message. So then I said, okay, he's not going to respond, so I'll say something on Twitter. Then he responds, and he says he's no longer on the board. Address it to Lynn Wood. So then I'm like, okay, well, Lynn can say this. Lynn refuses to respond. And so that's what's happening on the one hand. The second, on the other hand, extraordinary developments are taking place. One is Pierce is facing lawsuits of financial fraud from almost everybody you can possibly face. Litigation funders in the millions of dollars. Major problems with his in what he did towards his wife, to where there was domestic violence restraining orders requested. Crazy behavior, mentally unstable behavior you do not want your criminal defense lawyer, particularly in a high-profile self-defense case, to be making. And his former partner goes through all the problems. Details that he's never done a state criminal defense case in his knowledge in his life. I researched federal criminal defense. I don't find him doing anything until the Papadopoulos case, where he was briefly involved. So it appears he has no background in criminal defense of any kind, no background in Wisconsin of any kind, no background in Illinois of any kind, no background in bail, extradition, Second Amendment, self-defense of any kind, no general trial experience that I can find, much trial experience at all. And that almost all of his partners, he ends up breaking up, disassociating. They end up suing, he ends up in fights with them. There's allegations he owes massive amounts of money, allegations of financial misappropriations, allegations of financial fraud, exactly what you don't want someone running a charity handling money for. And then at the same time, Lynn Wood is sued by literally everybody in his firm. All of the lawyers in his firm file an extraordinary lawsuit of a kind I have never seen before. So one, you have every lawyer, all the lawyers who did all the substantive work on the Sandman case, they all leave, number one. Number two, they file a suit. And they don't just sue, they file a verified complaint, which means they signed under penalty of perjury that everything in there was true. And having background with those kind of cases, having represented lawyers in those kind of internal conflict cases, when they put in a bunch of detail more than they need to, and they sort of do that right at the beginning of the case, when normally you would hold that back almost as leverage, if you will, from a discovery trial perspective. If that's your goal, if what Lynn Wood's accusations that this was extortion was true, that's what you would do. You would hold stuff back. You wouldn't put it all in. When you put it all in, you're trying to give a warning sign, a warning signal, warning message to everybody out there. There's a serious problem here beyond the financial dispute between us. They have recordings, they have transcripts, they have emails, and what they describe as someone who is going nuts. Someone who refers to himself as Almighty Lynn, refers to himself as Daddy, has them come over and stay at his house because he can't handle something throughout a whole night for reasons that he never explains. That he behaves like an abusive stalker personality, back and forth from 1 hour to the next, 1 minute to the next, 1 day to the next in his behavior towards these people. That they accuse him of fraud, they accuse him of financial misappropriation, which makes me worried that he has some sort of money problem that is now could be contaminate the fundraising for Rittenhouse. And they detail, just deeply disturbing behavior. And it was not like generic religious behavior, more like God told me to do this. God told me to screw you over. God told me to cuss at you now. And I grew up in the religious fundamentalist background, so I know the difference between honest religious expression and people who are misusing it and abusing it for bad purposes. So when I finished reading it, I was like, Wood is nuts. And am I going to sit here and keep my mouth shut just because I know he's going to raise holy stink? A whole bunch of also Wooded has got involved with Q, the QAnon movement. He puts it right on the front of his Twitter page, which was not a good sign. I know all the Q people will hate me now. Please send all your hate mail courtesy of Viva Fry and Canada. Yeah, just kidding out there. But
well, the thing is this: I see comments and I see people, and people are entitled to their beliefs, and I pass no judgment to the extent it remains nonviolent and non-harassing. From a lawyer's perspective, however, when you're representing people and when you are representing prominent cases, even if you believe in certain things and you wholeheartedly believe in them, it's still not necessarily the best for your clients to publicly promote those things. People may not like this and they may call it a cowardice, but as a lawyer, you have a duty and a responsibility to your client not to do things on your own personal First Amendment basis that might compromise your ability to properly represent your clients. So and this is getting back to all of these problems and all of these lawsuits and all of these issues that the two lawyers are in. People are entitled to get into problems, financial problems. They're entitled to go nuts on Twitter. They're entitled to send really, whatever emails they want. But the problem is when that comes to a position or comes to a point where it compromises your ability to represent a client should not have to pay for your decisions. And it's a very, very delicate thing that you're bringing up.
No doubt about it. And the problem is the press is not going to take him seriously. He will not be able to be effective in the court of public opinion. And he apparently has a conspiracy theory that Justice Roberts is being blackmailed related to Epstein. It's a QAnon theory in part. He's now voicing that, verbalizing it. He's talking like revelations, and it's kind of like a combination of biblical revelations and Q's revelations. And the problem is that puts your Rittenhouse. It makes Rittenhouse look like he's a member of the John Pierce is comparing it to the Revolutionary War, and he's quoting the militia statute. So the combined public appearance of Rittenhouse right now by his two lawyers' presentations, some for their own issues, but just in general context, is that Rittenhouse is a crazy militia member who thinks he's part of an insurrectionary revolutionary army here to bring back the country from the trust the plan Q folks as part of a revolutionary militia. This is exactly what he did not need to look like. So that's the problem. And that's where it's like, why not just step back? They just let other lawyers handle it, transfer the money to the family. You did a noble thing by helping raise the money, make that the noble thing and step back and don't do anything else. And I'll address this other topic, which I'd been ignoring now for a year and a half, just because I know it. I'm already receiving criticism related to it. And Wood has already come after me again related to it. So for about a year and a half, Wood, the local lawyer there in Covington, and other people associated with them have smeared me and libeled me for a year and a half. I frankly didn't care. As long as it didn't impact my clients' cases in Covington, the fact that I have libel lawsuits against the so-called great libel lawyer was kind of comedic, but it was not something I did. I have no interest in getting involved in it. I hate office drama already. If I had my dream life, I'd, when some people say their nightmare would be living by themselves on an abandoned island, that's my idea of a good life. Just give me some Cuban cigars and Cuban rum, and I'll be good for good. I'm a natural recluse. People want to see evidence of this. Go back and look at the Wesley Snipes trial. If you read the transcript, I'm about 80% of the transcript is Robert Barnes for the defense. If you watch the media interviews, I'm about 1% or less. So I'm not a media guy. I don't need fame or fortune. Had enough of both. I do what I do because I believe it's the right thing to do. And I have strong opinions, as Uncivil Law says. He's like, well, how can you be so confident all the time? It's because I'm right on civil law. By the way, it's a great YouTube channel for people to follow is Uncivil Law. He did a really great breakdown of the CDC case we'll get to later.
Yeah,
but
and apparently did some good comment, did a good video on the comments of I don't want to say Joaquin Phoenix, but Joaquin. Someone can post a link because I brought the comment up, but
so yeah, I'll briefly address it only for this time period, and then I'm moving on from it. Throughout there was a bunch of time periods where basically there was a range of crazy conspiracy theories and that I was going to sue the Catholic Church. I hated Catholics. All kinds of crazy rumors were spread about me. I mostly ignored them. I deal with this. And, when the government comes after you, you have to pay a little more attention, but that's about it. In the context of that, he and the local council there, and here's the backstory for people who don't know it. I got involved in Covington doing the case for free for all the Covington kids. I never represented Nick Sandmann, never wanted to represent Nick Sandmann for a range of reasons I will not get into. Nick Sandmann's a nice kid. I mean him. I hope he gets the whole world for him. But he had different objectives than what I was interested in those cases and that my clients were interested in. I was not interested in secret settlements. I was not interested in paydays. My clients wanted less prominence, not more prominence. They didn't want to speak at the Republican convention. They wanted to be able to have their lives, still have those lives for their future. So very different objectives, very different goal, very different parameters, very different priorities. And I want public reform, public apology, public corrections, public retractions. There was people who followed it close enough could figure out that there was a gap between me and Wood's approach and whatnot. But I didn't highlight that because I wasn't trying to be critical of anybody else. I just wanted to do my own thing. Despite that, I got a lot of backlash. I got a lot of smear campaigns and libel campaigns waged against me. And the most common one was that I was going around telling people that I represented Nick Sandmann. It's completely false. I volunteered that information anywhere, any place, anytime that I didn't represent Sandmann. In fact, I highlighted in certain contexts because I wanted people to know there's a difference in our strategies, a difference in approach. That's part one of that equation. He's still doing it. He went down to Mercer Law School. He gets an award. He gets called a legend. And aside from like breaking down, crying sporadically, I mean, there's signs that there's something wrong with the guy. It was almost a cry for help, in my view, of what was going on down there. But he spends a whole bunch of time attacking me on it. And he tells me about it yesterday on social media. He highlights it. And I was like, if I'm right, the projection principle we've talked about, which is that people that will often project their vices onto you and your virtues onto them. He does a lot of that. The way he talks about me in other contexts, it's like when he's describing me, he claims he's describing himself, and when he's describing me, he's actually describing himself. So it's like, whoa! I was like, people should be paying attention. The guy, he's been talking about apparently retiring and other things. Whatever it is, there appears to be signs of a breakdown going on. And some of the behavior might be explained by that. I know lawyers who know him, who really like him, who vouch for him, who say they don't understand what's happened to him over the last 2 years. But the other component of the whole Covington backstory, just get it out there, done with it. You get an exclusive here on Viva Fry for all this. The in-house behind the scenes desperate lawyers, whatever it is, edition. That's why I hate all this. I'm the kind of guy that's bad at office politics in general. That's why I have my own firm. I just don't like dealing with it. But is that essentially they had I had recommended that they not sue don't sue your toughest defendant with your weakest case in your hardest venue. They went ahead and did so. That accelerated the timetable that I had to bring suit because they brought it in front of the other problem with this was don't sue for huge amounts of money. Don't sue for 250. This is general advice to people out there. Don't sue for crazy amounts of money because here's what happens. You get nice headlines that look good. The court system thinks you're a joke. They think you're grandstanding. They think you're not for real. They think you're not sincere. And I knew everything about Judge Bertelsmann, the federal judge. And that's why I wasn't going to file my first suit in front of him. I was filing state court. I knew that he would be skeptical of the case, but I knew if you filed suit that way, he was going to be overtly hostile and try to gut it. And unfortunately, Wood didn't listen. Now he had a lot of smart lawyers working with him. Those are the ones now all suing him, saying he's going crazy, basically. But what it did is it forced me. The judge did in fact dismiss him, and he was going to gut all the cases, and all the local state court judges I knew because I'd done all my research in advance. All look up to Bertelsmann as sort of the senior, great, respected jurist in Covington, because there's a federal courthouse just there in Little Covington, and he's been presiding over it since like Jimmy Carter days. So so I was like, okay, I got to accelerate my timetable of bringing suit, because I got to get in front of a judge that I can show him a different picture of this case. And part of it is I had a whole bunch of legal arguments already prepared. I'd prepared our legal arguments 7 months before. And in fact, by the way, the defendants made more arguments against me than they did against Sandmann, against Wood. They made better arguments, stronger arguments, and wider. But that's what happens when you sue like 10 people. They all have the best lawyers, and collectively they're going to be good. But interestingly enough, they missed some arguments, which I'm not going to share now, or I'll wait for many years from now. Let you know the arguments they missed. But so I was able to get in front of them. I figured the politicians would move it to federal court. They did. This will be a long to short transition into the Covington case, but the Sixth Circuit. And I was able to, and the key was not just my legal arguments, which were some of the legal arguments that ultimately Bertelsmann would use to reinstate Sandmann's case, to reinvigorate all the Covington cases for everybody effectively, but it was the political dynamic of it. So Bertelsmann is introduced to Covington with an out-of-town lawyer suing for $250 million, and he's suing everybody for that. He wants basically billions of dollars in damages, which would be, the biggest verdict was $100,000 in any comparable context in the history of Kentucky for defamation. And that had much worse facts than the facts that were present here, frankly, from a damages perspective. So I come in and I'm suing for real small amounts. I'm just suing for college tuition. And I got a bunch of kids, and they're suing a bunch of defendants. And I'm able to detail things that Sandmann couldn't. I mean, Sandmann went public. My kids did not. My clients were still getting harassed. My clients wanted to be private. This was now a doxing case. This was now about politicians being held liable for libel case. This was now about kids who just wanted college tuition for some of the most egregious lies that led to death threats, bomb threats, arson threats, physical threats, financial threats. And so when Bertelsmann saw that, I believed that I could persuade him to reconsider the case, because he'd be like, okay, this isn't just a big grandstanding case. This is a bunch of kids. Not just one kid, it's a bunch of kids. Many of the kids trying to stay private. Their families' lives have been made hell. And they're just seeking, and they're not suing anybody that actually issued any kind of correction, retraction, or apology. There's a bunch of defendants that could be in this case that were given the chance to get out, and they were let out. So it was the most sympathetic version of a defamation case you could bring. It was not a coincidence that I structured it that way. And I structured it knowing Bertelsmann at some point may look at my case. And I think that's why he reversed in Sandmann, because he was hearing the motion for reconsideration after he got my substantive briefing on the underlying issues. But despite that led to more criticism, other crazy stuff. So that's the whole background of Covington. We have different objectives. There's a lot of lies and libel about me. I'm not going to go sue everybody that's lying and libeling me. I got bigger fish to fry.
And now two things I wanted to mention. The first thing, this is without judgment on Ellen Wood or the strategy. Most people don't appreciate this. $250 million. If anybody were to take that, claim that amount in Canada, and we are not as litigious as the States, you don't get laughed out of the courtroom right away, but judges don't take that seriously. And in Canada, even $20 million would not be taken seriously. So the people don't appreciate that. They want vengeance. But you have to remain within the reasonable spectrum of what a judge is going to take seriously. Second thing, in terms of, my issue is not worrying about what I say on Twitter, reflecting poorly on my clients. Back in the day when I was doing, funny vlogs with my drone, and I was still a practicing lawyer, one weekend I waxed my leg with a drone. And I said, if a judge sees that, they might judge me in a way that would, compromise my ability to accurately, effectively represent my client. They might not take me seriously, and it might reflect poorly on my client. Now I think if judges watched my vlogs, they might take me even more seriously. But people need to be sensitive to these two things. Like what a lawyer does, even if it's within his or her rights, can have an impact on his or her ability to represent the client effectively. And claiming $1 billion in damages does not, and filing a 300-page lawsuit, it doesn't look more exhaustive. It doesn't look like you're doing a better job. It actually might just not look serious.
And to give you a comparison, I've defended a lawyer who brought a civil rights case for wrongful death, and the federal court dismissed his case as a sanction because he only asked for $1 million. And I got it reversed on appeal, but the Court of Appeals made clear they never wanted to see those kind of big demands made again. So so that's that the American system is even harsher. So like give you another example, in the state of Kentucky, you can't allege your specific amount of damages. That's why I can, for jurisdictional purposes, say it's under a certain amount, and here's what but I couldn't. That's why they couldn't have even alleged 250 million and filed in state court. That would have been a violation of Kentucky rules. So that gives you an idea of how serious Kentucky takes it. They hate it when people do this, and that was the problem that was created.
Very interesting. And now I've forgotten. I did not get to AJ Cook's super chat. Barnes, my best friend, a Maryland cop, got crucified in a politicized prosecution. FOP attorney, I'm not sure what that means.
Fraternal Order of Police.
Okay, FOP attorney in over his head, needs advice or referral. Would you please glance over his case? I put him in touch with your office and sent details last week. AJ Cook, sorry, better late than never.
Yeah, I definitely will take a look at those cases. And yeah, so that's the whole backstory of the reason I've always concerned, because I thought it'd be better to get the money to the family that's been raised. There's also issues with putting it inside a 501c4. There's self-dealing problems, private inurement problems. They're creating a tax disaster. In light of what happened with the Build the Wall people, they're subjecting themselves to potential federal criminal scrutiny. They're putting themselves in harm's way unnecessarily. I think they may have had the very best of intentions, but it's like at this point, the best way you can help Rittenhouse, if that's the goal, is step back, give the family the money, let them go pick a team of lawyers. There's a great Louisiana criminal defense lawyer that's itching at the bit to help out in whatever way he can. One of the top Wisconsin criminal defense lawyers wants to help. One of the top Illinois criminal defense lawyers wants to help. Whole team of folks willing to help, willing to work for cheap, willing to work on a discounted value, willing to work without even upfront guarantee of payment. Which is, in criminal context, criminal lawyers don't do that because they risk non-payment at a very high rate. So tons of people willing to help, tons of people eager to help, tons of people happy to help. And I did not, for a year and a half while I was being libeled, I said pretty much nothing to any of these people. I said nothing about them. So I don't wish bad thoughts on any of them. It's just that for Rittenhouse, he needs a different defense. I fear that his current defense, both of the court of public opinion and the court of law, will lead to a bad outcome for Rittenhouse.
All right, and two things. I'm bringing up Lenny London. It was a Facebook post by the individual who got shot in the arm, who said what he said his friend said. So it's third-party hearsay if you want to consider it that. It's worth what it's worth. Yeah. I don't know if that individual has been charged or arrested yet, the one who carried a concealed weapon to a protest.
Nope.
And who drew it. We'll see. And incidentally, someone else pointed out, it was Joel Raleigh said Viva is thinking of the Chipotle parking lot lady. Drawing
that's the other one. Yes.
That's what I was thinking about. Okay, perfect segue into you want to do Elizabeth Warren?
Yeah, sure. Because that would be an abbreviated one based on the poll response on Twitter. People had some familiarity with it, so they're like, "We want these other cases above this one." It's like, okay, I'll
put my homework to good use here. So Robert Barnes, a while back, appealed the decision of dismissing the defamation lawsuit of the Covington kids against Deborah Holland and Elizabeth Warren. I put out a video Friday. It's exhaustive. Pleaded it, and we had the oral arguments that I posted, and 70,000 people watched the oral arguments, Barnes and Robert. It was great. And then it got dismissed again on the basis of sovereign immunity, that that is not a speech and debate clause lawsuit. It is a sovereign immunity lawsuit under the immunity granted under the Westfall Act. The Congress members were acting within their employment by making contemporaneous statements on incidental political issues on Twitter, and that's where it stands. What do you have to say? I mean, first of all, how do you feel? It always turns my stomach reading a decision when I know it's not going the right way. I get nauseous. I get angry. Then you get to the end of it, and then you just pissed. Like, all that work for nothing. Now, I mean, how do you take it, and what do you do now?
So I was curious about how they would rule. I mean, I thought it'd be 2-1. I thought the Trump judge would at least hold his ground. He didn't. He wussed out, as a good number of Trump judges have when these kind of issues have confronted them. Unfortunately, not all of them have stood tall like Rao did. So I was disappointed in that. Not overly shocked, but disappointed. But the other component of that was that they did not address really my arguments, which was fascinating. They sort of created a straw man version of my arguments that wasn't my actual argument, which I take as a compliment, because it tells that they didn't have a good answer. And we'll explain, like, normally if that was their opinion and that had actually been my argument, they would have issued that opinion several months ago, right after the oral arguments. It took them several months to put this together. And they decided, well, we're just going to pretend he argued this rather than this. Because my core argument for everybody out there is that Congress passed the Westfall Act, and that the Westfall Act only did extend immunity to potentially to members of Congress. There's an argument that it didn't, but that wasn't my primary argument. My primary argument is all it did is codify the pre-existing immunity, because that's exactly what the U.S. Supreme Court said 8 years later after the Westfall Act. They said all the Westfall Act did was put the immunity that existed prior to the Westfall decision that the Westfall Act was overturning. It took the pre-Westfall decision case law about immunity and made that the definition of the scope of scale of immunity. And my argument is that's speech and immunity clause. And it's not that the speech and immunity clause governs and the statute doesn't. It's that the two are the same. It's that the statute defined what was within the scope of the duty for purposes of statutory immunity the exact same way the speech and immunity clause did, because that's what existed as immunity prior to the Westfall Act, according to the U.S. Supreme Court. All it did was codify what that case law held. And then my second argument was, even if it didn't, it should, because it's the most manageable standard. It's the standard that goes back to the speech and immunity clause of the British Parliament. It's existed for hundreds of years. So rather than having a different interpretation of immunity, which is what the Sixth Circuit has done, it's all each state's scope of employment law, which now we have 50 different definitions of what immunity is under the Westfall Act for speech. And my view is that's not a practical interpretation of the statute. There's absolutely no evidence that Congress intended that, of course. And so that my argument was, use the speech and immunity clause. You have not only 200 years of U.S. jurisprudence, you have hundreds of years before that of English jurisprudence. And then third, my argument was, even if you reject those first two, Congress, our founders specifically put in speech and immunity clause to say this is what the power of speech is that you're going to be immune from, and what you're not going to be immune from as part of the legislative branch. If Congress can just ignore that entirely, then Congress could pass a law immunizing murder. The Congress could immunize themselves from bribery. Congress could greenlight their ability to go kill their competitor, to actually physically kill them. And when during oral argument, they realized there were problems with that, so they didn't even go down the logical path of where that would lead, and then they just pretend that logical path doesn't exist in their decision.
Well, so and it's an interesting thing, and I was discussing it with Nate via text messages. Like, I understand the argument now. The Constitution sets out immunity for Congress members, and now what they've effectively done is just they haven't contradicted the Constitution; they've just added to it by way of legislation that. Not only do they have the immunity provided for in the Constitution, but they have total immunity. And I can understand the argument being different for employees in terms of federal employees who are carrying out tasks, and they're employees. They're not governed by the Constitution, or they're not provided for in the Constitution, whereas Congress specifically was. So what they've effectively done is amplified the constitutional protection to make it total immunity and not just speech and debate immunity, which.
It'd be like any branch of government just saying, you know what, I'm going to take over the legislative branch now, which is the criticism, for example, of both Trump and Obama on executive orders. If you can just usurp this power to yourself, then the entire constitutional system that's set up to govern us is gone, because any branch can just declare to itself that it has broader power than the Constitution ever allowed it or afforded it. Yeah. And the most problematic, what would stop Congress? Why not Congress agree with the president? Hey, Mr. Trump, or whoever the president is, you president, you agree, we're going to immunize you for all of your crimes. You agree to immunize us for all our crimes. We'll pass legislation that says if you're elected to a member of Congress, you could never be prosecuted for any crime you commit while you're a member of Congress. What stops that? Nothing, according to the Sixth Circuit decision.
No, they'll say that it would be a political response to that and not a judicial one. If people don't like it, vote them out of office. But
which goes to the other issue they hid. They tried to say, why in the world would we interpret this congressional statute any differently? There's a big reason. This started in 1987. The D.C. Circuit in the Sundquist case said, look, Congress, and that they said that maybe Congress could give itself more power than the speech and immunity clause. But by the way, that court said there would be constitutional problems with that, and it's the ones I'm talking about, that the court, this Sixth Circuit, doesn't even talk about, pretends it doesn't exist. The other component of that is what they said was, if Congress wants to have the guts to give themselves more immunity than the speech and immunity clause allows, they need to do so in legislation that's public and clear so the public can respond. The significance to the Congress never talking about this in the Westfall Act, most of them not even knowing that's what happened in the Westfall Act. In fact, many of them, I got Ilhan Omar to issue corrections and retractions in the Covington kids' cases because she didn't know this immunity could be this broad. So unfortunately, friends of Lynn Wood were going on Tucker Carlson saying otherwise. It's like, look, don't educate Congress on what liability immunity they may have. Let them keep issuing retractions and corrections, and maybe I'll be right about the law anyway. So that's the reason why Congress never had a public political reaction, because nobody knew that they did this. There's nothing in the law that says they're doing this. There's nothing even in the law that says, by the way, we're now extending it to members of Congress. So the idea that, we're just going to assume sub silencio that in fact that's what they always intended, was to give themselves extraordinary immunity. Well, maybe that would be fair if there had been the public had a choice to whether to elect them or re-elect them or to throw them out of office based on. They never got that choice. So the political processes as well failed. So that's why I'm taking it up to the U.S. Supreme Court. Okay. And my argument always on this was twofold. I'm going to take it up to the U.S. Supreme Court. Maybe they say yes. Maybe they say no. If they say no, then I'm going to prove that the courts are closed so that we can get change in Congress. And I already have members of Congress interested in the case now that they're seeing how egregious this is.
Amazing. Well, that answers the question as to whether or not you're appealing. And that's, like I said, incidentally, I wanted to put in a Silencio meme in my analysis of the decision, but I didn't want to get copy claimed by some troll. So, okay, well, that's fascinating. I think that's as much as anybody need. Well, as there is a talk about now, it is. I can already see it. It does garner a lot of disdain, to be polite, that these Congress members who, for the longest time, on the one hand, have been dumping on Trump for what he does on Twitter, and talking about, he should be removed from office for tweets, and talking at the same time that no one's above the law. Well, I guess technically they're not above the law. It's just that the law, it's good to be king.
Yeah, it is good to be king. I mean, they're above the law. Everyone else is. You cannot libel a member of Congress. They can sue you, but a member of Congress can libel you. And it used to be supposed to be connected to their legislative duties inside the chamber. Now it's anything that's political, according to the Sixth Circuit. Well, that's everything. What couldn't be called political?
No, where they said the tweets referenced build that wall, which was part of Trump's policy to build a wall on the southern border. Like, okay, so I mean, there's little that occurs on Twitter that could not be loosely tied to politics. I mean, I think everything on Twitter is tied to politics. The question is, was it done in the context of their employment? And they're saying, yeah, their constituents want them to comment on trending political issues.
Which what it meant was the Sixth Circuit was saying these constituents retain these people so they would go around and libel kids from other places. In fact, they retained him so they could libel them.
No, that is a way of framing it. What they're basically saying is, we want them to, on the spur of the moment, tweet what they think of an issue, even if it comes out that it's inaccurate. Where it becomes, I know where you're going with it, is it becomes libelous when it's no longer by the facts. They refuse to issue a retraction or apology. Yeah,
and they know if they did a poll, 90% of the people in every district in this country, left or right, would say they do not want their members of Congress to have a license to libel.
I mean, I tend to agree. Especially when, at the very least, I mean, I know knowing the history and knowing the facts is all you had asked for from the beginning. Take the tweet down and issue a correction, which Deborah Haaland and Elizabeth Warren refused to do. I think Azra, what's his name? Azran?
Now I'm blanking on his name. CNN guy. Reza Aslan. Yes.
He finally took his tweet down, right?
Yeah. What happened is that was another place where we were trying to get him served. I had hoped that Wood would sue. Wood never did sue him, and so I was like, okay, I'll go ahead and serve him, because even though his statements was toward Nick Sandmann, the way that was interpreted and applied hurt all of my clients. Because he was a CNN guy, he had an extra reputation, and he was the one calling for violence, and it did not stay limited to Sandmann. And so I was trying to get him served. He'd been dodging service. We finally got someone that was about to serve him. And I think he knew that. He must have known that, because within an hour of me hearing, hey, by the way, I think we got him, all of a sudden he went in and deleted his tweet. And so I just tweaked him. I was like, yeah, I guess he heard about the service providers coming by. Thanks, Reza. You're done from my side of the aisle. And of course that led to somehow a scandal. Like, I got attacked by the local council that was working for Sandmann was trying to take out Thomas Massey. He was organizing a political campaign against him. I think he ended up with 12% of the vote. He ended up with this long history of like racism issues and whatnot. So I was trying to stay out of that whole thing, but I somehow got dragged back into it for Reza Aslan's case. But everybody who deleted the tweet. Everybody who corrected, everybody who retracted, everybody who apologized was not sued. The people who were still suing are only those people that did that. And I give it as a distinction. Some people have been asking about, I guess Pierce has been talking about he's going to sue Twitter for $1 billion and bankrupt them because he or Wood were briefly suspended. Those suits are frivolous, folks. That has zero chance of success. Now, I say that as a guy who brings suits that other people say you can't bring. I bring suits like this because, one, it had not been clearly adjudicated, number one. Number two, there were good, sound, non-frivolous arguments that, in fact, I was right. And everybody's conceded that along the way. Nobody's claimed my arguments are frivolous in any respect. And three, the only way to get congressional change was to at least to show the courts are closed, if, in fact, the courts are closed. Find out if the courts are closed. Challenge it. Contest it. Take it through. And I'm doing all this for free, so it's not like I'm using it to get money for myself or something. By contrast, these days, everybody should realize Twitter, Google, they're functionally immune from suit. For almost anything that they do, and the courts are closed. And anybody telling you there's relief in the court system is either not being smart or not being honest. And the reason why that matters is we need to put all of our pressure on Congress. That to say, Congress, you need to change Section 230 because the courts are closed, and here's all the egregious ways that they can censor speech in the public square. Again, the Sixth Circuit Covington case also said that the social media is the public square, so another recognition of that reality. They're never going to impose the First Amendment on it. The courts have made that very clear. A lot of us across the country have litigated this, not just me. We tried to get access to the courts. The courts made clear they're closed in every jurisdiction. So the only way, so when people ask, is Lin Wood about to bankrupt Twitter, make a bunch of money? No, none of that's happening. That's just a waste of time and effort. What needs to be the focus on is there needs to be a focus on changing the law because the courts are closed and Section 230 needs to change in the way Senator Hawley and now Senator Cruz and other people are saying. And there needs to be maximum pressure, but that pressure will only happen if Congress realizes that pressure from the public, and the public will only bring that pressure if they realize there's no remedy in the courts.
And if enough of them know about it, because
yes.
It's the media is not jumping on covering this case, and they're certainly not jumping on reminding Elizabeth Warren about this. Incidentally, just so everyone understands this part, not to be accused of defamation. Resla Aslan outrages Hindus by eating human brains in CNN documentary. In case anybody didn't know that and didn't get the reference from why is Blue 923 taken, no, I wasn't bringing that up to make a joke. That actually happened, and it made news back, a few years ago.
Razor claimed he took down the tweet because his wife asked him to. So it was just coincidental that the service server was knocking on the door.
Well, I'm frequently reminded that happy wife, happy life. So he might have made the right decision for a number of reasons.
Either way, I was happy with the outcome.
Segue. Mail-in ballots, because I think that was one of the ones that got the more votes, right?
Yes, it was. Mail-in ballots was so to another topic of political fraud and corruption in our modern day and age. So there's different rules in different places, and the key issues with mail-in balloting that's different than absentee balloting is with absentee balloting we have these safeguards built into the political process. So the first safeguard is you have to request that ballot, and you have to meet certain standards in the way your request is done. Sometimes it has to be notarized. Sometimes it has to be witnessed. Sometimes you have to provide certain information that only you would know. But basically, the first safeguard is that you request that ballot before it is sent to you. And then secondly, there can be certain safeguards built into that in terms of who can proving that you, in fact, requested it. The second safeguard is that someone notarizes it, someone witnesses it, and then the third safeguard is it is returned in time to be counted. Those three safeguards are being removed at various levels in what Trump calls mail-in balloting. So when Trump says mail-in balloting, he means where the state just sends ballots to anyone who's ever been registered to vote in the state. Regardless of whether they, not even checking the list about whether they're active or inactive in some contexts, whether they've moved, whether they've died, things of this nature. And that's the biggest objection. The second objection is the method by which that ballot is returned. In some contexts, they allow what's called ballot harvesting. So in other words, rather than you delivering it to the election offices or you delivering it to the postman, someone can go around and gather it. And gather a bunch of ballots and all produce them at the same time. That's the second area of controversy, the method of delivery of the ballot. And then the third is the timing. So the question is, do you have to return the ballot by election day, or can it be returned weeks after election day and still be counted, as long as it was quote unquote postmarked by a certain day? And then you get into postmarking standards, and making sure the postmark is actually being monitored. And so those are the different issues with it's when the ballot is returned, by what means the ballot is returned, and by what means you get the ballot in the first place. Those are the three areas of legal controversy that now there are federal lawsuits brought by President Trump's campaign in Pennsylvania, in Virginia, not Virginia, Pennsylvania, I think partially Michigan, Montana, Nevada. And they have a good argument that they put together some good key talking points about the risk of that mail-in balloting clearly poses a higher risk of ballot fraud than does absentee balloting. The concern is that people could get more ballots than they could be entitled to. In other words, when someone has to request it and meet certain standards to be able to even get it in the first place, far fewer ballots go out. Whereas like Nevada had hundreds of thousands of ballots returned that we've sent to people that didn't live there. And those were the ones that were undeliverable. What about people who got like at apartment buildings? You'd see, a whole tray of ballots. Someone could just grab them and fill them out and sign them and send them back in. What's to stop it? How do you prevent it? So the risk for fraud goes up as the safeguards go down. And so the argument Trump is making is a multiple argument. One is that there's voter dilution is going to occur because voter fraud risk is higher due to a lot of these methodological issues. The second argument is that any ballot returned after election day can't be counted because that violates the one election day rule, which is mandated by the federal statutes that election day can only happen on or has to happen by a particular day. And so those are the two main constitutional and statutory arguments they're making. They're saying equal protection due process violation because there's voter dilution, because voter fraud dilutes the effectiveness of the vote of those people who did not participate in the fraud. And that goes to all the issues about where ballots are being sent, how many are being sent, when they're being sent, who can gather them, where they're being sent back, risk of coercion. Because, nobody's with you when you walk into the ballot box. Whereas you could have 10 people around you when you're signing your absentee ballot. And they could make sure you did it, quote unquote, the right way. So there's coercion risk. There's bribery risk. Hey, $50 if you sign this ballot and you've marked who I want you to mark here. So all of those risks go sky high and that's why you have a notary present. Like the obligation of a notary present is the notary's there to say no one else was there. They weren't under any pressure. No one else got to see who they voted for, so on and so forth. By removing those safeguards, they've created constitutional voter dilution issues by their heightened risk of voter fraud. And so the two grounds are they're allowing ballots to be counted after election day. That violates I think that's the strongest, easiest claim for them to prevail on. The second is voter dilution due to the nature of mail-in balloting.
I just don't understand. First thing, I don't understand now the argument for it, considering Dr. Fauci says voting in person is fine. There's ways to do it safely, easily. So I don't know where the pressing concern for this reform is. I guess the other question is, it is reform. It's not. This has not been done prior to this election, right? The early voting is one thing, but at bulk mailing out ballots has not been done before.
Not in very few states. So Colorado does a version of it, and California has been doing a version of it since 2016. So so California allows ballot harvesting. So this is where it got on Republican radar. Was on 2018, it looked like Republicans were going to hold a bunch of House seats in California and on election night. And then a week later, all of a sudden, a whole bunch of ballots come in and Democrats flip all those seats. That's when they realized this was a massive operation of a different scale than they anticipated. And it's very hard to prove voter fraud. You can show unusual tendencies and whatnot, but it's just very tough to prove. And in fact, mail-in balloting is the easiest and most effective way to do it. Both Attorney General Barr and all of these lawsuits keep citing the study done in 2009. That was a bipartisan commission that included James Baker and President Jimmy Carter that said mail-in balloting posed the greatest risk of voter fraud to America's elections. So there are a few places that have allowed it. Oregon has a form of mail-in balloting. There are states that generally don't have a high history of voter fraud. And they still have certain safeguards in place that are not fully in place in some of these other states like Nevada. So I agree. The theory is the easier you make voting, the better. I agree with that, but I think there's ways to do that that are consistent with both privacy and security of the election. I think we should use blockchain type technologies that allow that to occur, so you can still have privacy, still have security, but still have ease of voting. But it's no doubt that there's a reason why almost only Democrats are pushing for this, and it's not because of COVID. In Nevada, they're real blunt about it. In Nevada, they did have open ballot, for election day. They're going to have places you can vote. It's just in Democratic precincts for the most part. The rural Republican areas got no voting places you could even vote if you wanted to. So I mean, it was just one big power grab. That's what I think it really is. I understand a lot of the people on the left, on the electoral legal side, would say, look, this is about maximizing participation. That's what democracy is all about. Mail-in balloting will achieve it. Connecticut, at least Colorado and Oregon have had success with minimal allegation of fraud concerning it. So that should be our priority focus. But the COVID itself is not really grounds at all to have this mass mail-in balloting campaign.
Now, as far as it goes, I understand it's not entirely feasible if you want to vote early to go get a notary to witness, an early or an absentee. What is it, an absentee vote? An early vote. But I don't see how you can avoid problems. This is again, I come from Canada, where when I want to vote in municipal elections, 2 pieces of ID and a proof of address. So the idea of not having voter ID as a starter is foreign to me. And I don't, how many countries in the world do not have voter ID laws? I think US and there's one other, right?
Yeah, very, very few. I remember I was in England a couple of years ago, and we was on a bar tour, a great pub tour. As part of it, there was a guy there from India, and then there was this lefty guy that was sort of leading the guide, and he was talking about how America's so corrupt because they were going to try to require voter ID. And the guy from India was like, "Hold on a second, you have elections you can vote without voter ID?" And he didn't expect this from a liberal guy from India. The lefty, it was a lefty from Canada, actually.
I remember this. I remember the incident.
So it was classic. So given the whole nature of it, I think I am sympathetic with the idea of maximizing voter participation entirely. I think we can make voting much easier than we do. I like the way they originally did it in Nevada. Nevada, when you'd vote on this computerized system, but they would give you your receipt so you get to keep it, which I like that. I like some method of receipt if you need to. But it concerned me that but this invites fraud and invites litigation, which is, I think, unless Trump wins by a solid margin or Biden wins by a solid margin, and by that I mean 2 points or more in more than 270 electoral votes, we are going to have Bush v. Gore on steroids come election day.
Yeah, no, and incidentally, corruption aside, fraud aside, sorry, I didn't mean to bring up that. The issue of the coercion is something that I don't think most people are thinking about. Like, your grandmother or your mother getting, or your grandfather, your father, like an older person getting a ballot, and someone comes to their house and says, "Hey, we saw that video on Twitter of the LA lady going to visit her Iowa family, or Ohio, I forget which, going to try to convince them not to vote Trump." Well, for someone who's easily not even manipulated, but over whom a younger person exercises control, there's no telling what can happen. Once you get behind the ballot box, and it's only you in that box, but you got to put it in an envelope.
And between husbands and wives, if my ex-fiance was around, I guarantee you I wouldn't be doing any mail-in balloting, because it was only going to have to go one direction, or I would have been out on the street. So God bless her. So there's that dynamic with a lot of people. So, I mean, because these days politics is religion, particularly for some people on the left, it's the substitute for religion. So I think there's problems with the way Democrats have rushed this. I think it looks bad. I think if you were truly wanting a little de-democratic process, you would have come to agreements with both parties, found ways to make it easier to vote without and accommodate anybody's COVID concerns without creating massive fraud exposure.
Okay, and I'm going to bring this up because I get to practice, or I get to show off my French. The Patriote canadien Maine says, "Viva frère, j'aime ton émission. Question, pourquoi s'ils savent que c'est anticonstitutionnel, meilleur mot dans Scrabble, de voter par mail, ils laissent aller ça." So, I love your show. Question, if they know it's unconstitutional, best word in Scrabble, to vote by mail, why do they still insist on doing it?
Well, I mean, they think it's legal. I mean, for them, this is about maximizing. In fact, they think it's illegal not to require it. There's actually lawsuits along those lines. Their view is voter participation. Their perspective is this: the Democratic perspective, and a lot of your election legal scholars that lean left would say this is just Republicans trying to suppress the vote because an honest election would throw them out of office. That's how they see it. They see it as a long history of trying to suppress black voters, suppress immigrant voters, suppress poor voters, poll taxes in the South, things like that. And so they see any obstacle not as about avoiding voter fraud, which they claim is a myth and doesn't exist in any meaningful manner. They're not credible when they do that, by the way. I've been trying to tell my left-leaning friends on this side of the aisle that don't make that pitch. There's so much history of voter fraud. It goes way back. It happens every election somewhere, someplace. It's only about whether they get caught. But that's their perspective. And so that's that they see this as constitutional, and that a real democracy would make it extremely easy for everybody to vote. That you should be able to do like drive-through vote balloting, mail-in balloting, email balloting, phone balloting, you name it.
I know the joke that Trump made that he got in trouble for, mail in and then try to go vote in person and see if they still have you down. Knowing how there's lag, knowing there's confusion, knowing that you might get two ballots to two different addresses with the same name and they go to two different stations. It's so not preposterous to think they would, how many people are not just going to go try to vote a second time and see if they get caught? Oh, you get turned back. Good. If you don't do it enough, and you can make some headway. It's not. Everything's been so politicized that the suggestion that this might be a flaw in the system is now being politicized, but it's just common sense that there are lags, there are miscommunications, and it's inevitable. So if enough people go try to test the system, enough might get through to have an impact.
Yeah, no doubt about it. So it's a major risk. I hope Trump is getting all the lawyers lined up. Because if he doesn't win by 2 points or more in enough states, the lawsuits are flying. And Hillary Clinton came out yesterday or the day before. There's that great video with her and Bill.
With Bill Clinton in the background.
That's going to be permanently memeable. It's classic Bill. He couldn't hide his why am I here? Why can't I get away?
I try not. I mean, I try. I don't generally partake. I do not partake in making fun of those types of things, but my goodness, Jack Posobiec was going nuts with it. James Woods was going nuts with it. I mean, they were memeing it. And yeah, it was, there was one where they were playing Hello Darkness, My Old Friend, and just slowly zooming into Bill Clinton's face. Okay.
To that super chat real briefly, by the way, the super chat about whether it goes to Congress, the way it's not a majority House vote. You vote by state delegation. So Trump would likely win that. So throwing the race into the House will not help the Democrats. They need to win it outside of the House. But what Hillary said, by the way, was she said that Biden should not accept the results of the election and should not on election night. And so that means they're planning on massive litigation.
No, and this coming from, and CNN is saying the same thing. What happens if Trump refuses to accept the results of the election? It's pathological projection. It's pathological projection. And I think it's even worse. I think it is a dog whistle to get people ready to get up on arms if they don't win. And talking about the political permission slip, that's how I view it, and that's how I interpret it.
And it was very important for Democrats that they won the governorships of Pennsylvania, Michigan, and Wisconsin in 2018. So it means those states, you have big Democratic cities, Milwaukee, Detroit, and Philadelphia, and Democratic governors controlling the state election machinery. So the shenanigan risk is going to be unusually high. It's going to look like 1960, where Nixon had to go quietly into the good night, even though they were still counting ballots from dead people early in the morning.
All right, now I want to bring up one super chat, which I can't bring up. I'm just going to read it. I'm going to bring this one down. Zombie. Okay, why can't Trump and the DOJ already start suing states to stop this mail-in ballot nonsense? If we can stand in line at a store wearing a mask, how can we not stand in line to vote?
So the Trump campaign the Justice Department considers it beyond the scope of their issues to deal with.
Okay.
It's another area where bar is not particularly helpful.
Okay. And now we're almost, I hear footprints, and we're better off not going past 2 hours. Mother Issues asked this twice. Please ask Robert Barnes about 14th Amendment, Section 3. Does it not make Biden-Harris ineligible to hold office based upon their Antifa bail posting? That might not have been the one. I think I might have pulled that up already. Hold on. Let me just get, it was a Mother Issues. She had another question. Oh, sorry to be an ag. Read 14th Amendment, Section 3. If not tonight, maybe a vlog. I think it's important 14A differs from all other states, was written to prevent another civil war. Okay,
I'll have to look at that.
Okay, and I'll send you the screenshot just so we have it. We have 7 minutes left. If we assume we have 7 to 10 minutes, what else do you want to touch on?
Well, so let's do 1 minute each for the other case we referenced. So, or 60 seconds flat. See the and then maybe a super chat question or two. So on the Rochester case, I'm concerned that people are getting so hostile to BLM narratives that they ignore a case that BLM really didn't promote when it first came out, and that they just presume that the cops are right and the defendant is wrong. That's a case where I believe that his civil rights were violated. I believe it was excessive force. I've litigated spit mask cases in great detail. What happened is
Explain to, because I've read and I read what both people say on what both groups say on both sides. The spit mask. Explain what it is, and then explain why it was used in theory in this circumstance.
So a spit mask is when someone's spitting on an officer in such a way that it poses a real health risk to the officer, usually very close proximity, things of that nature, then there's a specialized mesh mask that they can put on them that is supposed to be able to create space so they can breathe, doesn't compress on them. But the quality of the spit mask radically varies from jurisdiction to jurisdiction. There's no consistency used. The second aspect is, in my view, they're way abused. The reality is the risk that someone spitting into an officer's eye or mouth leading to that officer suffering serious health consequences is less than 1 in a million. And you're talking in the absence of my Sharona. We're talking pre-COVID. Right, exactly.
During COVID, we'll get to that, but these are designed for non-pandemic use.
Correct. Yes, that's exactly right. Number one. And number two, where he was at, he was far away from them. They had 4 to 8 feet distance. He was outside. It was in the cold. So the idea that they faced any serious risk of health from him spitting on them was low. By contrast, when you put a spit mask on someone, all kinds of things have gone wrong. There's been a whole bunch of deaths related to spit masks because often they use the wrong spit mask. Second, the spit mask is done in such a way that the person asphyxiates because of something else that happens. So I litigated this case in Wisconsin. The person died because of misuse of a spit mask. The cops misinterpreted it. He wasn't spitting on them. He was suffering physical consequences leading him to bleed. I mean, the giveaway is he was urinating and defecating on himself. But these cops had become so dehumanized that they're like, oh, he's doing that to cause us harm. He's deliberately urinating on himself to tick us off. I mean, I'm sorry, I don't have sympathy for cops who become unhuman. I get it's a difficult job. I get they're underpaid. I get they're right now being taken through the burner politically. That still doesn't mean some aren't bad, and it still doesn't mean some lose their humanity along the way, and that makes them dangerous to innocent people. I think the cops that showed up that night showed signs of dehumanization. They were laughing at someone who clearly was suffering a mental illness breakdown, had a toxic ingestion of drugs. The person's naked in the middle of the cold, in the middle of the winter, in the middle on the street in Rochester, babbling incoherently half the time. That's someone that needs mental health treatment and physical health treatment, not someone to laugh at, spit mask, shove his head into the ground for 2 minutes, and then later the consequences from it, according to the coroner, dies. So I knew when I put something up on Twitter, I was like, it will be the backlash that I've been talking about to legitimate civil rights cases because of BLM only pushing divisive narratives. Not a surprise that BLM, once that case did get some national notoriety, BLM didn't jump on the case right away, which was a sign, by the way, it was a legit case rather than an illegit case. When the case did get national news anyway, then what does BLM do? They go and riot, right? So that they're just like George Floyd, to take away the uniting effect that case could have. Because spit masks, some of us in the civil rights arena have been saying, look, if you're a cop, nobody wants to be spit on. It ticks you off. But the problem is, as a police officer, you have to balance risk. And it's an unfair position to be in, but it's what you signed up for. You can't tell a cop, I have a 1 in a million risk of severe harm, so I can create a 1 in 10 risk that this guy dies. I'm sorry, that's not a trade-off. That's a worthy trade-off. Without the spit mask, that guy's not dead. I have no doubt about it. I have no doubt an expert would have testified to that. Spit mask was not warranted under the circumstances, and definitely you can't spit mask him and then shove his head into the ground and hold him for 2 minutes.
For anybody who hasn't seen the video, when they put his head into the ground, he's hands cuffed behind his back, right?
The whole time. The guy has no weapon. You know he has no weapon because he's butt naked in front of you. You already handcuffed him. He's on the ground. He has never even tried to stand up. And so you decide to spit mask him and shove his head into the ground for 2 minutes in the freezing cold, and for which it suffered asphyxiation according to the coroner's report. There's much better medical evidence of that hold causing and the spit mask causing his death than there is the George Floyd death. That case, in my view, is more egregious than the George Floyd case. So you had a longer length of time in the George Floyd case, but you didn't have the high risk of severe harm that you did have in the Rochester case. So in my view, that was excessive force. Again, please send all your hate mail courtesy to Viva Fry on Twitter. Otherwise, yeah, so that's our, it might have been a little longer than 60 seconds.
No,
but
that's
my
you know
Rochester.
you reminded me, because the one that we should maybe dedicate more than 5 minutes to, if we can, I'll see when I start getting harassed or texted by my wife. Senator Lucas arrested, and former Mayor Fred Heidmann arrested. And let's do Fred Heidmann, because I don't know how that video now has 400,000 views. That's the Minnesota mayor of Nisswa, I'm mispronouncing it, who was caught verbally abusing police. It's inexplicable. It's inexplicable. I mean, I immediately thought intoxication, but I had no, there was no evidence to suggest it. When he came back with his truck, if they didn't give him a sobriety test, they didn't think it was an issue. Verbally berates police officers who are conducting the stop of a third party. Pulled the car over because of apparently illegally tinted windows and a loud muffler or a loud device. The mayor, who works down the street, sees the incident, crosses the 2-lane highway with his dog, busy traffic highway, and proceeds to berate the police officers, calling them dinks, which apparently means doofuses, effing this, effing that, blah, blah. Leaves, comes back, and gets arrested. For anybody who hasn't followed the story, Friday, Nisswa City, or the Nisswa municipality, had an emergency council meeting, which I listened to for the relevant parts. They approved a resolution, 3 resolutions. One was to censure Fred Heidmann. The second one was to ask that he resign. And the third one was to strip him of his position of office. I don't know how it works now that they approved all 3, which doesn't give him a chance to resign. That's one situation. Senator Lucas is the senator from Virginia who was inciting protesters to paint, cover a monument with paint. A few hours later, apparently after she left, after she left, the monument was then destroyed, taken down, fell on somebody's head, caused life-altering injuries to that person. She was subsequently arrested on conspiracy to destroy a monument or conspiracy to damage property in excess of $1,000. And there was another charge. I forget what it was right now. My issue with Senator Lucas, starting with that, is if it turns out that the monument was destroyed 3 hours after she left or an hour after she left, does that not undermine the charge against her, when her argument will be, all I was doing was telling them to paint the monument, which would have been less than $1,000 in damage. I wasn't telling them to destroy it. That occurred after I left. So on its face, the charge is going to be very weak.
I think, well, the nature of it, it's because of what she said on tape. It's her statement that she had the authority to overrule the police officers and told them that they could not get involved. And so what they're going to say is that she put everything that happens after that, she put into motion. And so in a typical conspiracy case, for folks that know, you can watch on Vlad TV, somebody like Free Ray Ricky's talk about how he hates conspiracy for good reason. It's that if you're involved at any point, you're responsible for everything that happens, even if your role is tiny and you had no idea of the full scope of the consequences. So if the same laws we use conspiracy laws in the United States to put people in prison for 20 years, when all they did is say, have one deal on a street corner, and they're held liable as if they're a massive drug lord, by that legal standard, which is well developed here in the United States, she's going to be responsible for literally everything. They could have even held her responsible for the physical harm, because it's the same like felony murder we talked about in the Arbery case. So it's once one thing happens and you were part of it, and all you have to show is you were part of it, you're responsible for everything unless you withdrew publicly from that act prior to the bad consequence occurring. And that's like a crazy high standard. So the short answer is, under the very broad conspiracy criminal laws we have in the United States, she likely does not have an effective defense.
Okay, interesting. And what I love is I don't know how this is going to play for or against her, that she's in a disguise. She acknowledges in the video she's in a disguise, and she's telling the police officers to not arrest them. They're going to do it, and you're not going to arrest them. I was just wondering, is there not, maybe it's a political solution and not a legal one, but is there not an abuse of power charge that she could have faced?
Generally, no. In the United States, most of our abuse of power provisions don't exist in our laws anymore.
Okay, that is a clear enough answer. So that's the Senator Lucas one. We're going to see where that goes because, what ended up happening in the wake of that? Now they passed a law to make it a misdemeanor, not a felony, to assault police officers.
Yes, and because the local prosecutor won't prosecute the case, so they're having to have other people to bring the prosecution because the local Richmond prosecutor is one of these people that George Soros and other left-oriented groups put in power, so that you have another place where the weaponization and politicization of prosecutorial offices are taking crazy directions in the United States.
All right, and I mean, I don't know on the Fred Heidmann Nisswa, Minnesota thing. I don't know that there's much more to add to it. It's just
epic.
It was an epic moment of what the heck are you thinking? Who are you doing this to impress? I had a bunch of theories as to why he might have been doing it to try to impress, whether or not he was doing it for social media brownie points. Inexplicable. I would still tend to forgive people, but I do think he has to resign or be removed from office because during the city council emergency meeting, you heard other people talking about how he bullies them in the workplace environment. There's a bigger issue going on there than that 30-second worst moment of his life, probably.
And not only that, I mean, his dog did get loose, and the dog had run in front of a car could have died.
Yeah, or caused an accident that killed people. I mean, it couldn't. The timing of it, I said it was comedic timing, but it could have been tragic timing, depending, if it had gone another way. It just could not have been scripted better. I don't know what the F I'm doing, and his dog pulls himself out of the leash right after. Okay, let's see. We got Red Viper says, Barnes, what can we citizens do to help the Rittenhouse case?
That's a good question. I mean, really, maybe a different fund has to be set up. People were right. GoFundMe's not allowing Rittenhouse's defense to raise funds. His family raised funds through GoFundMe. A Christian group raised money. My understanding is they've raised already over $1 million. It's just sitting in a bank account that Lynn Wood and or John Pierce control, apparently. So one is that they just release the money to the family, and that the family have that money, and then the family make decisions from there, and then a team can be put together. That's what should happen. If that does not happen, I don't know what the next stage is to try to correct what could be a serious problem.
And I say share the videos, and people may not agree with Robert on the legal assessment. I think it's relatively bipartisan, the assessment of the defense. Just have people know the facts, and they'll come to their own determinations as to what they can do and how they can do it. Isaac Castillo says, how big of a cloak is sovereign immunity for Warren when it's clear the libel suit with the Covington kids does show defamation, intent, and recklessness? What is the remedy? Well,
one of my other concerns was that at the oral argument, they had seemed amenable to the fact that I was saying, look, intent is a fact question for discovery, not a pleading question. But they've said now, basically, if the comments could possibly relate within 20 degrees of separation to something political, you're immune. And so it really means you have a license to libel, because everything a congressperson does can be considered political.
Okay, and then Metazone says, any chance you can ask Robert my previous AG question? Think you took a screenshot. Let's see if your observation is better than my memory, Metazone. No, I got the real Bamboonga. Metazone, I don't think I wait, no. Okay, so post it again on the bottom, and I'll get to it right away if I can. Sorry about that. Let me just
briefly on the CDC eviction question.
Yes.
I was just going to say, Uncivil Law did a great breakdown of it. Short answer is no, the CDC does not likely have the constitutional or statutory authority to prohibit anyone from evicting anyone in the country. However, this is Trump playing smart politics. He's like, okay, who's going to sue? Let the landlord sue. I'm on the side of keeping people from being evicted because of COVID. Are Democrats going to sue? They're not going to sue. So what will happen is probably 3 or 4 months after the election, they'll set that order aside and never try it again, hopefully. If Trump gets reelected. If it's Biden, maybe they'll just try to green light it. But I think if it gets litigated, it clearly violates interstate commerce clause restrictions. The statute doesn't even authorize it. The statute is designed to be consistent with the limitation of congressional regulation to interstate commerce. And so there's at least an interstate commerce connection to civil rights laws, but also civil rights laws can be independently passed because of the 13th, 14th, and 15th Amendments to the U.S. Constitution. So no, it's not likely constitutional. Yes, it is smart politics for Trump. Also, I have a bias against landlords. If people wonder, is it rational or logical? Probably not. It's just old-fashioned bias and prejudice from life experience. That's probably not well warranted. I understand some landlords might see this thing differently, but politically, it's good for Trump to be on the side of not having grandma kicked out of the house pending the election. But legally, no, I don't believe the CDC has the authority to use the excuse of a pandemic to start to govern local housing law.
Okay, and I found it. Metazone, thank you, Metazone, for putting it back up. Would Robert accept AG posts? Would you make it past Senate? Need DOJ house cleaning? Robert,
when I make it past the Senate, there's no way the United States Senate's going to let me get anywhere near any position of power.
I was going to say, you might have. I could anticipate your problems, and they might be, unless there's a massive swing in the general politics, they might be insurmountable.
Yeah, if Trump really wanted to send a message, he could nominate outsiders like me. It doesn't need to be me, but it could be anybody. By the way, apparently Lynn Wood thinks he's going to be the Chief Justice of the United States. That's a whole other thing. That's what I mean by guy's gone.
Actually, just put a comment that Lynn Wood has met President Trump and you haven't. But
and that's well, actually, I have met President Trump. I just don't do a photo of it and show it to everybody.
Oh, touche. Jay Mills says our friend Tim Pool had an interesting vid today on the number of left-leaning district attorneys currently. Another great discussion. Thank you very much, Jay Mill. Thank you. And that fish in that picture is beautiful.
It's almost as nice as that smallmouth you caught the other day.
This is nice. So I think that looks like a brown trout or a Dolly Varden.
That'd be one of my brother's favorite. That's why he loves the trout fishes. He loves them because of how they look. And to me, I'm like, fish look like fish to me. So,
I love pike despite how they look, just because they fight like beasts. And the smallmouth bass I caught over the weekend just fought like I thought they were pike. Great. Okay, we got Musological says, great stream, guys. Sorry to bug, but the question of using RICO against BLM and Antifa is still floating around. Sen Cruz just called for it publicly even. Thoughts?
It's not practical. So RICO on the civil side is very limited. Criminal maybe, but on the civil side, you have RICO is the Racketeering Influence Corrupt Organizations Act. It was passed in order to go after the mob for extorting and infiltrating businesses and using legitimate businesses for laundering illicit sources of monies and for extorting those businesses. Once you understand that purpose behind it, wasn't used functionally until the early 1980s, as is depicted in a Netflix documentary about Giuliani going after the mob in New York, because a law professor at Cornell had been recommending it beginning in the late 70s. And until then, the mob had no clue it could be used that way. But civil RICO, they've interpreted in more limited ways. I was one of the only lawyers to successfully bring a civil RICO case against get it past both the dismissal and summary judgment and appeal stage against a law firm, actually. But I can tell you from that litigation, it is very, very difficult to get someone on RICO. What you need is some corrupt group of actors using some other entity or business to do their corruption. And so people think RICO and they think organized criminality. That's not actually what RICO is much more limited, in fact. You need to be infiltrating a legitimate legal business operation or entity or set of activity and then doing it. So if Antifa was operating out of dry cleaning shops, then yes. But because of the way they're organized, it'd be very difficult to bring a civil or criminal RICO case against them. You could just bring general conspiracy charges on the criminal side.
Okay. And I think that might be a good place to end it. What do we say?
Yeah, I think just two other brief ones. We'll see if it did 60 seconds flat. Just because I want to, for the McDonald's discrimination suit, it's a good suit. They do have allegations of racial discrimination and disparate treatment by McDonald's, including with a time frame where McDonald's went from doing one thing to something different. Basically, they took African Americans, told them, hey, why don't you go work in the ghetto McDonald's, which has a bunch more problems, not only safety, security, lower volume, but also buildings that needed substantial repairs, but did not recognize that in the way they economically treated them, and often denied them the opportunity of moving out of the ghetto. Basically, they didn't think they could get anyone else to work in those McDonald's, whatever it was. They're basically effectively ghettoizing McDonald's franchise owners and forcing them into the ghetto as the only place they could functionally do their business, and were treated in a disparate way economically that caused them severe discriminatory harm. So I think they have a very good case against McDonald's. Ironic that McDonald's out there saying Black Lives Matter while they're busy discriminating against young Black and entrepreneurs, young and old Black entrepreneurs. So that's the McDonald's case. It does look like a good, clean case. I think it'll probably settle at some point. But the McDonald's has been back and forth with this for 50, 60 years. They have an unfortunately ugly history of racial discrimination against Black business owners. And then the NSA spying case. So the NSA did finally, the Ninth Circuit recognized the NSA's mass gathering, mass spying campaign was in fact illegal, that it violates both the statute in terms of how it's been crafted and the Fourth Amendment to the U.S. Constitution. Unfortunately, they didn't do anything with it. They refused to enforce that in the suppression rule, so that the government is still allowed to use it in criminal cases in terms of how the Ninth Circuit interpreted it. It was still good to at least get recognition that it was illegal and a major violation of privacy. It was one of the first judicial recognitions of the importance of Ed Snowden's work, which is also important and relevant and pertinent. Ed Snowden is one of the greatest whistleblowers in our history. Julian Assange is the greatest publisher of whistleblowing information. So when I see people out there bash those guys on the right who claim to be anti-deep state, you're not. You're a deep state hack who has a misunderstanding of the fundamental history of our whistleblowing laws and the ways those two guys have acted. So it was a great result for people, but not the scale of result that needed to be placed, because the courts are not going to enforce it in a meaningful way that will penalize or punish the government for their misallocation and for their illicit spying on the rest of us.
And incidentally, I remember why this sounded familiar. We talked about this with Eric Hunley as well, in a little more detail. If anybody wants to go check that out on his channel, it was last Thursday's live stream with him. Actually, one last thing, Robert, before we end this. Flynn, there have been developments that I'm not aware of. There was a new proceeding filed, I believe, for expediting what Sullivan's supposed to do.
Yes. So, the en banc decision is not a surprise, as we discussed previously. What the unfortunate, but not a surprise. Interestingly enough, nobody's talking about going up to the U.S. Supreme Court right now, but that clock can go on if they want to. I would have tried going up to the U.S. Supreme Court on an expedited basis, but everybody makes their own decision. So both the government and Sidney Powell have requested that the hearing be held. That there not be a bunch more briefing, and that the hearing be held by the end of September. It looks like Judge Sullivan will agree with that. That doesn't mean he'll actually issue a ruling. He's just going to have oral argument. It looks like Sullivan did get the message not to do an evidentiary hearing, did get the message not to try to do discovery. So he did. So that's where, when people say, well, why did you bring something that didn't work necessarily? Because think of laws like chess. Each piece has a role. Even if you sacrificed one, you gained something else. And so by Sidney Powell challenging that aggressively, she got the Court of Appeals to send a message to Sullivan so that the most egregious aspects of what Sullivan was trying to do will now not be present in the proceedings.
Yeah, I mean, and that's something we talked about, is that from the arguments, or from before the Court of Appeal, even from the arguments, one thing was clear: none of the judges think that Sullivan has much leeway to do anything other than dismiss. And if you want, they made that clear. So, like I say, it goes back to Sullivan for that to happen. But what was the question? Oh, taking it to the Supreme Court, in my mind, correct me if I'm wrong, would be pretty silly, given Sullivan now has pretty clear directives what he has to do, and taking it to the Supreme Court is just going to waste another 3 months to 6 months and cost another $50,000-$100,000, even assuming it gets there.
Well, only if you ask for a stay. You wouldn't have to ask for a stay. So you could ask to take it up to the Supreme Court on grounds that, and even if the Sullivan gave you the relief, you could say that this is a mootness exception. So the idea would be to try to get the legal issue adjudicated while letting Sullivan continue to march forward.
All right, interesting question. Can Trump pardon Rittenhouse after he is reelected?
State charges. So Trump's pardon power is limited to federal powers, to federal criminal charges.
Okay, and that would, even if it were federal, I imagine the politics behind that would be.
Trump would be the kind of guy to pardon him if it had been federal, but it won't matter because they're state charges. They need the governor of Wisconsin to pardon him.
Okay, interesting. And now Dapper Dave says, what qualifies for a case to be sent to the Supreme Court in an expedited fashion?
You just request emergency relief from the Supreme Court.
Okay, good enough. And Snowden is a Putin propaganda mouthpiece.
Yeah, it's just not true.
I
understand Snowden ended up in Russia because it's the only place that would protect him from the United States government, but he originally went to China. I originally went to Hong Kong because he thought Hong Kong would protect him under their traditional laws, and they just caved to political pressure. This is while they were not fully controlled by China. So Russia was the only place where he was safe. But the idea is that he's actually been highly critical of Putin. And so I get there's the different criticisms of Snowden. You could argue that what he revealed was known in some quarters, but it had never been publicly confirmed. And there's a reason why the Ninth Circuit's citing him and not anyone else.
Okay.
So I get that those two are topics where people get up on their back heels, just like Chelsea Manning. The reality is Chelsea Manning disclosed horrifying acts by our government. And so if you're okay with that, you're on a different side of civil liberties than me. So so that's fine. Have at it, but don't come telling me you're a constitutionalist if you think that behavior is okay.
All right, and we'll end it with this. You two gentlemen are good people and wonderful patriots. God bless you, and thank you. End to the unknown. Thank you very much. And that is a good time to wind it up. Robert, they're always amazing. We always have something good to talk about, good in the legal sense and interesting. This was another phenomenal stream. Podcast is going to be out tomorrow, and I'll try to break it up into sections. Everybody, thank you all for I'm looking for the camera. I don't know where I'm looking. Thank you all for tuning in. Thank you all for the questions, the super chats, the support. The support above and beyond everything else. We're getting some good viewership, and we're getting this, spreading around to the point where people are actually agree or disagree with Barnes, agree or disagree with me. I'm not generally highly opinionated, but you're learning stuff that more people should know.
Absolutely. And it's always great. I love these more than I like other mainstream media appearances because they're more educational, more informative, more democratizing access to the law. And it's great to have, and to have ordinary everyday people have access and to be able to self-educate and self-inform, because that's the way change really happens over the long time. Over the long term, change happens when the ordinary everyday person becomes self-educated, self-informed, and acts on that self-education and self-information.
Amazing. Everyone, have a good rest of the 2.5 hours of the weekend. Robert, we'll say our proper goodbyes afterwards. Everybody, peace out.